Let's just do this. Yes. Except please delete the I there. The chat is not. Delete the I there. Yes, delete. May I please observe the protocol that was established yesterday before I stumble? And wish you a good morning. For the presentation on our part, we are dealing with part 8. As you see, the first contribution came when we got to part 8.1. We were dealing with a visit of justices. There was a need to add on the text, and so one of the additions came with the edge there, which, as you see, was to verify that all prisoners, including pre-trial prisoners, have access to legal representation.
Excuse me, Mzwandile, can you increase the font?
It's not, it's, yes.
Yes.
Please, TM, please use the mic. We are doing this presentation with my learned friend.
Yeah. And I took advantage because I'm his senior. So can you add I that we omitted, that a judge Pixie added, observe and report on access to educational, vocational, recreational, and rehabilitative programs. That's the one that we erroneously omitted. Yeah. Sorry, rehabilitative, I think. is the word. Rehabilitative programs. Yes, yeah.
And then we move on to 6, just below that. There again, we had additions to 6A as appears there. That is, a visiting justice should inspect records at the correctional center to ascertain the following. The addition there is the adequacy and the records keeping system, including the maintenance of registers for admissions, release, and transfer, and medical treatment. We also added a new, if you go down, we also added those as part of the additions in that section. If you move a little bit down again, you will see on 817, on 7C, the addition there was to consider, so it is, a visiting justice must inquire into early release mechanisms to encourage good behavior and rehabilitation of prisoners. A visiting justice must, if you go to C, consider the condition and the release of incarcerated pregnant women and women with children in the best interest of the child, or if the best interest of the child required it. Just to explain the discussion there was with regards to women who are then found to be pregnant in prison, treated differently from women who are found in prison with children. So the distinction is that you have the one who is found pregnant and then the others who have children. Now, the discussion also included the fact that this might be a case where the particular lady is suddenly pregnant, having been in prison for a period of time, or was brought into the facility already pregnant. May we move on to 9? In that one, the correctional officer must accompany all visiting justices for their safety and shall provide reasonable assistance in their inspection. The issue was it should be the assistance for reasonable assistance to ensure that they are safe in doing their inspection, and it shouldn't be in such a way that it impedes their carrying out the inspection. And then you move to 822. This one was a rewording of one that was there earlier. It was totally changed. To a judicial officer must ensure that any allegations of torture, cruel, inhumane, or degrading treatment or denial of due process are immediately reported to the relevant investigative or prosecuting authority, and that steps are taken to secure evidence and to protect the complainant. Because it was a question that it mustn't be only identifying, but there must be processes that follow to ensure that there's redress. May we move down? 283. Four. No. Yes. There again, this was a change of the heading. There was previously a heading, but now the heading was changed to within a week of receiving the report from the visiting justice, the Chief Justice must. And the idea behind it was that I think previously the visiting justice was reporting to the minister, but then it was a question of the justice reporting to the Chief Justice, and that the Chief Justice would not report to a minister. So that is why it was then changed to the wording. Now, we had a discussion in the group, but then we left it. You will see in the previous text, the first word is report. Now, because the Chief Justice reporting to a minister would be an anomaly as such, so the word that was introduced was raise any abuse observed in a correctional center to the relevant minister. The general issue being it's not reporting as such, but bring to the attention of the minister the issues identified. And also B, upon receipt of a list of pretrial detainees in prolonged detention from visiting judge, the head of the judiciary shall take further action. We also changed that one because the Chief Justice would not then report to himself. And the last one was also a question of bringing this issue to the relevant minister and not reporting as such, because the minister wouldn't, or the Chief Justice wouldn't report to a minister. I trust we did justice on behalf of the judges. I'm kind of hoping I'm not attracting contempt. Okay.
Hi, thanks for this. I just have a question. In terms of avoiding duplicity of work, so for instance, in Mauritius, we have ratified OPCAT. So we have the National Preventive Mechanism Division, of which I'm the head of. So our mandate actually covers a lot of the things that the visiting judges in this instance would do. And in fact, in our Reform Institution Act, we also have the provision for the Board of Visitors, which is supposed to be constituted of magistrates mainly to visit. And they also have a similar mandate, but the issue that we have in Mauritius, and this is a question because obviously we don't have an answer to it, but very often we find that there is duplicity of work in terms of visiting, in terms of complaints. And we at the NPMD, for instance, we have the manpower because we have investigators, we have barristers like myself, and so on. We also have members, psychologists, whereas the Board of Visitors or the magistrates or visiting justices, obviously we have talked about how judges have, a lot on their plates already in terms of judgments to hand down and so on. So in reality, we know, for instance, in Mauritius that those magistrates don't have necessarily that kind of time to go and visit all places of detention or follow up on complaints. So how could we, in practice, bearing all of these great ideas in mind, how do we avoid duplicity of work? How can the NHRIs work together maybe with the visiting judges so that maybe they complement each other in a way? Because, we know how it is in practice, and how often would judges actually go on site? And so just an open question, yeah.
Is there any other question? No, I don't see one.
The issue on, and it's a small technical point, but officials accompanying visiting judges, I think it's always good practice to say that they must be within sight but not within earshot. In other words, that the judge can interview people confidentially, and that the officials are not there to eavesdrop. The issue of bringing things to the attention of the judge and the judge then relaying that information to another functionary, I'm inclined to say that one should afford discretion there. The principle is to do no harm. And so sometimes a visitor, a judge, may come across information, but to disclose that information to the head of center or to a minister may actually result in harm being done to that individual prisoner unless there are proper mechanisms in place to prevent that. So I'm not too sure if I have alternative wording available, but the issue is that one must not make it an obligation. There must be discretion. And then there was issue about a suggestion that the Chief Justice must take certain action, and I'm not too sure what that meant regarding the people awaiting trial for a long time.
And so those are the questions. It's duplication of work and how we can complement. It's the issue of relaying information further, and it's the issue of the Chief Justice taking further steps when they are detainees.
Yeah, and that official must
Be within an earshot.
not in earshot,
eye shot. Eye shot, not earshot. Thank you. I don't think I should be answering on behalf of the group. I can volunteer, but I would ask.
Maybe I can try just to answer one, I think, or two. On the issue of duplicity, I think first and foremost is there are different mandates. The visiting justices have their own mandate when they visit prisons. National human rights institutions have also got their different mandates. But there is nothing wrong for a justice, visiting justice, where need be, to combine his visit to prison with national human rights institutions. We have done it before in Malawi, so I think that can be done. And on the issue of the Chief Justice is, the Chief Justice can direct, maybe through practice directions, what needs to be done for those who are awaiting trial for too long, and maybe even choose special magistrates or judges to handle those issues. That's where the Chief Justice in sometimes comes in. Thank you.
Thank you.
Thank you very much. Justice, on the point of education, how binding are the pronouncements and recommendations of a visiting judge or justice? When you go to, apart from what you can do, which is release people immediately if you find that they're being unfairly treated, but if you make certain recommendations, how binding? What can you do? Do you go back to find out if indeed those recommendations have been followed up? And are there penalties? Are there instances where a judge has said, because I issued this instruction or this advice or this order and it was not? Can a prison as an institution or the head of the institution be held in contempt of what a visiting judge would have said, and what are the penalties? I'm just, yeah.
Thank you so much. Let me defer that to Justice Zuki, not to put her on the spot, but in our group this issue arose, and I think she gave a very good response about the different mandates as a judicial officer or as a visiting justice. So I don't know, Zuki, if you could, yes.
Because you've touched on it, can you? I suspect I was cleverer yesterday.
All right, thank you so much. I think yesterday you had explained that when you make a decision in prison as a judge, that has to be followed. But as a visiting justice, when you make recommendations, they might or they might not be followed. But if they are not followed, the issue is escalated to some other authority, who in other countries may be parliament, then parliament will call the respective officers and then put them to task as to why they have not followed the recommendation. Thank you.
Madam.
Thank you very much. Good morning, everyone. In view of the fact that we're focusing on parliamentary oversight, this is a tool that is going to be used for parliamentary oversight. Do we see parliaments overreaching into the judiciary? And what type of connection and oversight are we envisaging? Do we not have already provisions for judicial oversight in prisons in our jurisdictions? And how would this incorporation enhance oversight of parliament? Can we make sure that linkage is very clear so that, or the inclusion is clear so that we don't want parliament to do what they ordinarily do not do?
Is it for me again or?
No, it's actually food for thought for all of us to look at how this and yeah.
All right, SG. I think to me, the major problem, having been involved in these issues in prison before, I would want maybe the model law to address an issue which you have delivered your report to Parliament, for example. And I gave yesterday an example where now Parliament is debating and they are ridiculing the report. Do you think we should make prisons into hotels? And sometimes even Parliament has got the report, they do nothing about it. I think to me, maybe what we need to concentrate on is when Parliament, which is empowered to do something, does nothing, what do we do? And how should this legislation address that?
Who should do? The judiciary?
No, I'm saying like in my country, when you have got a report, you deliver it to the minister where need be, as the inspectorate of prisons in particular. You deliver it to the Minister of Homeland Security. And the Homeland Security Minister is supposed to table it before Parliament. And Parliament is supposed now to implement what this report recommends. But most often times you find the members of Parliament are not interested, and then nothing happens to that report. What then should happen? I think, to me, I think that's fundamental, that we address that.
Thank you, Judge. Madam.
Thank you very much. I think primarily when we're talking about visiting judges, this is already a well-established system in our jurisdictions, right? So what the model law must do is to strengthen that system and ensure that compliance orders are actually issued by the visiting judges, and with some form of sanctions if the correctional services do not comply, because that's the link. And then the report that will come from the visiting judges will go to Parliament, as the parliamentary committees and parliamentary service are the check on the executive. So once they read the report and give directions or ensure that the executive actually carry out their functions in accordance with parliamentary orders and standing orders, then the link is established. We can't say, what if Parliament does not do anything about it. It's not Parliament's work. Parliament is just the check. So it's the executive that carries out the undertakings or the instructions that are given in the visiting justice's report. All that Parliament can do is keep nudging the executive, and the executive will have to answer ministerial questions, provide what they call government assurances, which are checked at every session of Parliament to ensure that the government is actually carrying out the assurances that they for National Assembly as to oversight emanating from the oversight reports. So that's how it works. So the linkages in the model law must be very clear out from the visiting judges to the compliance orders, to the election services, to the report made, to the executive and Parliament. The processes will come from the tail end when we are now discussing parliamentary oversight. What happens under parliamentary oversight? But we need to create the clear linkages between all these visiting justices and other institutions and Parliament. Because here we're talking about SADC, remember SADC PF, that's mandated over Parliament and not the executive. So it's the linkages which is important. Thank you.
Thank you, Madam. Jebra?
Thank you. It has been a debate that from the decision or from the recommendation by the judicial, we know when the judicial visited prison, they are visiting in administrative capacity, and they make recommendation or they make some opinion. So the issue becomes then, at the end of the day, whether it's reported to the minister, it's reported to the head of collection service, report to the parliament, there are still will be whether they will obey it or not, whether they will implement it or not. So I think we need to have an option, because being a recommendation or being a report is not binding. We need some decisions which are binding. So at the end of the day, we may open the forum for maybe the victims, or maybe the Bar Association or the National Human Rights Commission to have an option of taking the matter from where it's end to court, so that we get a decision in order for the executive to comply with the order of the court. At the end of the day, if it's go to the parliament does not comply with it, because complying with it is just it's needed political will. If they are not willing, then it's over. But when it's on the order of the court, then they have to comply with it. So at the end of the day, we should open the gate for matter going back to court. So if it's a report from a particular judge, then it might go back to court, but not the same judge, to another judge who can determine and make orders so that they can be complied with. Because we find that some of recommendation might be a recommendation to the change of the law, might be recommendation to the change of the policy or the practice. So that change need to come from the order of the court so that it can be complied with. So we should find the way through on how it should go back to court, so that an order should come from the court, so that whether it's a parliament or whether it's a minister, he or she should have that something to push them to comply with.
Thank you. There is, I see two more hands. On the questions that we had earlier, maybe the judges would also think about this one that wasn't attended, that is being an earshot away. It is closely linked to what the judges will recall we discussed yesterday. We were talking about dealing with personal grievances and requests from an individual. there was an account regarding the safety of the judges when they do that. Perhaps they would think about responding to that also. The three hands, that's the first one, this is the second one, that's the third one. I think we need
Bom
headphones.
dia. Meu nome é Daniel Joaquim, de Angola. Eu penso que, em relação àquilo que nos apresenta a lei modelo, há de facto uma harmonização, mas também existem algumas contradições que julgo que devem ser aperfeiçoadas aqui. É preciso que esta lei modelo não contraria a separação de poderes. Existe uma separação de poderes hoje nos Estados democráticos de direito. Temos o poder dos juízes, os juízes têm a responsabilidade de administrar a justiça em nome do povo, a Assembleia tem a responsabilidade de fiscalizar, criar leis e fiscalizar os atos do Executivo. O Executivo tem a obrigação de concretizar uma política pública. Então, penso que os juízes visitantes, existem matérias que eles podem discernir diretamente conforme a lei modelo já nos apresenta. Por exemplo, aquelas questões de garantias de direitos fundamentais, que não tem nada a ver com o Executivo. Se os juízes visitantes forem numa unidade prisional e encontrarem, por exemplo, um prisioneiro que tenha sofrido maus tratos, por exemplo, ou que não tenha sido garantido o direito à saúde, eles têm mandato, do ponto de vista legal, pelo menos em Angola é assim, de poderem garantir os direitos deste prisioneiro. Estamos a falar aqui em Angola, nesse caso seria os juízes de garantias. Nós temos os juízes de garantia, nem todo juiz faz visita. E também há uma separação em relação do sistema lá em Angola em relação à jurisdição. Nós temos juízes de jurisdição comum e juízes do Tribunal Superior. Normalmente, essa questão das visitas, elas integram na competência do Conselho Superior da Magistratura. É este conselho que tem. E as opiniões que antecederam fazem todo sentido, principalmente da doutora que falou, em relação às visitas que os juízes devem fazer e a quem eles devem reportar. Me parece que os juízes devem, sim, apresentar, quando forem questões de garantias administrativas, eles devem apresentar estes resultados, os relatórios, para o Parlamento. Porque é o Parlamento que depois tem o poder de fazer a fiscalização perante o Executivo. Aqui há uma contradição, me parece que é no ponto 8, quando diz que os juízes, os serviços prisionais devem prestar contas aos juízes. No meu país isso vai ser impossível. Ou seja, os juízes têm a competência ou o mandato de poder verificar se a execução das penas, se a reabilitação do recluso está a ser em conformidade com a lei e os direitos fundamentais deste recluso estejam a ser garantidos. Caso não estejam a ser garantidos, o juiz tem competência para fazer com que os direitos sejam garantidos naquilo que lhe cabe. Caso seja a concretização de um direito econômico-social, porque eles obedecem o princípio da progressividade. o executivo pode dizer que não tem condições para colocar água. E como é que fica? Então, é preciso que a lei modelo, de facto, esteja harmônica em relação ao novo ideal de democracia que muitos países africanos já têm. Nós temos uns países africanos que têm constituições muito modernas. Agora, falta nós olharmos para estas leis modelos no sentido de fazer com que os juízes cumprem o seu mandato sem atropelar o mandato dos parlamentares. E os parlamentares também exercem o seu mandato e impulsionando o executivo a concretizar a política nacional de cada país. Obrigado.
Thank you.
Thank you. I'm concerned about this particular 8.3 sub 2. The head of the correctional center must implement all relevant recommendations and suggestions from the judicial officers. The first paragraph, I think, is fine. It's a recommendation that's made. They enter the visitor's book and it may be considered and so on. So I don't have an issue there. And with subparagraph 3, there's a written report that must be submitted to the correctional center, but I don't think a judge can make an order there and then for a head of center and not even an option to, to decline. So my suggestion would be just delete paragraph 2.
I hear you, Prof, and I'm not disagreeing with you. But I think let's stay on with this point because earlier during the debate this morning, we debated the whole thing about what happens in circumstances where the inspectorate has made a report and the report has gone to Parliament, it has gone to the minister, but nothing happens. So we are worried about that. So I'm not saying let's not delete that, because I was going to argue earlier that if he must do something about it, then it would be easier to take them up in court and challenge their inactivity, because they are obliged to do it. But I'm not saying it needs to be there and it has to be framed that way. But what I'm simply saying is that it must not escape our attention that for the purposes of discussing that, we have to deal with that concern, which is a real concern, that it may be a waste of money if an inspectorate does everything and then his recommendations are just ignored. Thank you.
Now, I've seen 2.5 hands. There. It was, and the 2 hands I'm sure were, so before you respond, Anek, let's start with the 2 hands and then.
I think it's important for the model law to couch these provisions in the manner we couch them in normal national laws. For example, if we have a part or a section, a clause on compliance orders, which we do in most model law, whether the child marriage law, GBV law, HIV law, all those, we have compliance order, and the judiciary have those powers to actually issue compliance orders. But if we use wording such as implement all relevant recommendations suggested by judicial officers, really, these are not recommendations. They are abiding by judicial, international, and regional standards, which must be complied with, which our countries have signed off on. So their compliance orders are not recommendations. So in model laws, we follow the language of the normal law. and we follow the jurisdictions given to competent authorities. We never depart from that. Because once you depart from the competence of these authorities, then you're going to go into the problems that my colleague from Angola has said. You're going to impinge on the separation of powers, and that's not the intention of this law. And that's why I think he's calling them contradictions. The idea is to provide pure links on oversight that will work for the benefit of prisoners. That's what the intention behind this model law is. So let us be very careful on the language that we use. And I'm talking this out of years and years of experience. Otherwise, we may find that this model law will not pass even the committee stage of SADC-PF.
Thank you very much, and good morning, everyone. I want to apologize for having come in a bit late, so I may be repeating and or contradicting a debate that may have taken place. But I'm taking it forward from the point of Prof. Lucas to the extent of indicating that recommendations from a judicial officer should be complied with. And I'm not sure if whether these are actually compliance orders, because I think we must make a distinction between a judge visiting a prison, coming back, whether it's in the visitor's book or elsewhere, and reflecting observations, and someone actually taking the correctional services to task through court proceedings. I have seen, I can share this with you, that just a month ago or so, a parliamentary oversight committee had made very strong recommendations towards a parastatal. The parastatal took the parliamentary committee to court, and the court set aside the recommendations of the parliamentary committee. So that's the extent of separation of powers that you see. You also see that it's not cast in stone if a parliamentary oversight body makes certain recommendations. So to the extent that judges, I was just asking the Deputy Chief Justice what they do, despite the fact that they haven't done those visits in a long time, what they do with those reports, for example. So I would imagine if we are true to separation of powers, that the recommendations from a visiting justice, those observations are recommendations to the executive, because in the end, the executive is actually the oversight body for correctional facilities. I'm not talking about independent oversight. So I agree that number 2 should be deleted, because I think it's not a compliance order unless you tell me that we have gone to court and it was actually made an order of court. Then you're talking about a different process altogether. Otherwise, we are starting to pit different state organs against each other. We have to be careful about how we manage those relationships, because even compliance with international instruments is subject to your resources at a national level, for example. So I see that Eve is intimidating me, Chair, by continuously shaking her head for every point I make. So yeah, let's take okay, so I just want to say that I agree with the Prof, and this has always been my slight discomfort with the manner in which judges should get involved with this process. But I think I have accepted the philosophy behind it, but I would agree with the deletion of that one. Thank you.
Anek.
I've even now forgotten what I wanted to talk about. The SG made quite a pertinent comment that resonates with the work that we all do. And given the multiplicity of what we all do and the reports that we actually end up having to issue, I think coming from where I am seated and given the recommendations that have been made here, it's quite important for us now to build also another layer to ensure that Parliament will ultimately get to address the reports that are issued by the judges. And I think, given the experience that we've had, it's quite important that perhaps it should be built within their standing orders that within a specified period of time, they should have engaged with the reports and also address them within that period. And redress should also be given and be communicated within reasonable timelines. Thank you.
Thank you.
Hi, everyone. I just want to make sure we're on the same page. In countries like Malawi and South Africa, there's an independent inspectorate of prisons headed by a judge. So the role of that judge is different from a visiting justice, and there's a separate section in the draft before us specifically on the designated independent oversight body. And at that point, when we discuss that designated independent oversight body, we need to discuss, are their decisions binding? And that's separate from this section, which is about an ordinary visiting judge or magistrate and what their powers are. And it's separate from the NHRIs and whether their decisions are binding. So I just want to make that distinction. An ordinary judge's report is never going to end up before Parliament. The Judicial Inspectorate, the formal independent body, their report ends up before Parliament, and that's mandated. But now, not all countries have such an independent body, but all countries have a practice of judges visiting. So in terms of Boema's point about the separation of powers, how far do you want an ordinary judge's decision to go? So in terms of an ordinary judge over centuries, the pure fact that they visit a prison is already a deterrent in many ways and a way in which prisons understand that there is oversight. A judge who goes to the prison, I think, ought to have a feedback mechanism where they send their report on the visit to their department, to the head of the court or to the, and it ought eventually to end up with the Ministry of Justice, because it's a separate issue. It's about judges. So judges, when they go to a prison, they identify two things. Once they identify whether the rights are complied with and those sort of things. And that they record in the visitor's book. But at the same time, they identify that there are too many pretrial detainees and there are other problems with many people hanging in prison on bail that they can't afford or whatever. So then they're identifying stuff that's directly linked to the criminal justice system and stuff that only the Ministry of Justice can attend to, as opposed to correctional services. So when a judge comes, they actually identify two different areas of improvement. And I'm just wondering if we can think through what then happens. I remember that there's often been a concern that a judge goes to a prison, they have a report, who do they send the report to? Who even reads it? What then happens? And there could be, for example, a situation where if a judge or a magistrate goes to a prison, they observe certain things, they send that to the head of court or wherever as identified. Eventually, you almost want that to end up with the Ministry of Justice, because they're the ones who are going to report to Parliament. And they must say, this is a problem in our system that we've identified. But I don't know how they would report to the ministry responsible for correctional services, because it's not their, they don't even have a relationship necessarily with them unless it's the same department. I'm just wondering that how do we make the visits of judges meaningful, but acknowledging that there's a limit to what they can do. There isn't really apart from India, I've not really come across countries where a judge can just issue a compliance order by visiting a prison. They can see that there's a problem, but then there ought to be a process like that has been identified. But I think an independent inspectorate that's a designated body, they might be able to issue a compliance order if we think they ought to be able to have those powers. So we'll get to that section later. I just didn't want us to mix up the different duties. Yeah.
I note the new hand. I might be found guilty of overlooking colleagues. Siamo Head, his hand up, and the vice chair, his hand up.
Thank you. I think Prof suggested that there should be discretion. I think maybe we should just revisit that comment. I don't know if we addressed it. Discretion on the part of judges. It was the context at the time, I think, was when we were looking at 8.2.2.
Discussion about what is reported.
Or what is reported. Okay, because I thought it was 8.2. Judicial officers must ensure that any allegations of torture, cruel, I think maybe that's what you meant. Maybe I didn't get it right. So that your mention of discretion was that, should we tamper with that?
Yeah.
How? What's your proposed amendment?
The issue is about reporting something and you are not protecting the source of that complaint. And so the issue is about reprisals. So the judge may be very well meaning in saying Anneke Meerkotter was tortured, but then this news gets around and suddenly she finds herself being transferred to a prison 1,000 kilometers away. So I'm looking, and I'm sure if we look around, we'll find wording that will fix this. Something like, I see Sasha nodding her head. I'm hoping she's putting up her hand and telling us how to fix this. We can look at it, but for me, the point is that there must not be an obligation to report everything because it may be harmful.
Yeah, so if memory serves me well, I think Judge from Zambia, I think you're getting it from an international instrument, this proposed amendment, and that's how it's couched, if I'm not mistaken.
I think what we were merely doing is trying to strengthen 8.2 and 8.3 by making them more complete, enforceable, and aligned with best practices for judicial oversight and international standards, such as the Mandela Rules, OPCAT. Yeah.
Vice Chair, are you still there, Victor? You've withdrawn. Did I forget you for too long? No. Okay, thank you. You're covered. Sorry, sir, you had your head up? It's forgotten. Yes.
Thank you very much. What I'm saying here is very clear about what should happen perhaps during or immediately after a justice has visited a facility. And I'm just wondering, does a visit by a justice to a prison facility be announced beforehand? Should the facility know that we're expecting a visit by a judge? Is it something that we need to worry about or even talk about as we develop this? Many years ago, I trained as a teacher, and when people are coming for what is known as external examination, either you're an exceptionally bright student, they need to verify that, or you're a hopeless case, they need to verify that. You'll just find them knocking on your door. You're not told that expect next week, and what they get is the true reflection. I'm thinking, is it necessary for us as we draft this to ensure that we provide guidance as to, does a judge announce that I'm coming? Or should they come only during working hours? Can a judge rock up at some facility just before people go to bed or something like that? Because I think there's a difference between a visit that is pre-arranged and announced beforehand. You find everybody there. The prisoners have taken a bath, they've all been given Vaseline and things like that. Food is available. As to when people just come, when we don't expect them. I don't know whether that is an important consideration.
You answer. Okay. But also Victor wants to answer.
Victor, you answer.
I think these are supposed to be expected with the visits, because the moment you tell them that we are coming, they'll actually give them Vaseline, and they'll make sure that they should sweep the surrounding. As a inspector of prison in Malawi, we have the mandate. We can visit even at night. We just go, it's prompt visit. But I think the only problem with us, our arrangement, is that in the prison, the inspector of prison, we also have the head of the prison facility. So definitely, if we are planning to go to a facility, he tips them that they are coming. But otherwise, you are not supposed to alert them. Maybe for justice visits, they can actually notify the facility that I'm coming to visit. But it's not necessary.
I think let us not belittle the purpose of these visits, because they play a very fundamental role, as Aneka has said. When you look at as you go down, I think there is provision for visits without indicating or giving notice. That is allowed. I think as you read down the rules on that part. But again, let us also be aware of the fact that once you visit and you establish certain malpractices, or you find congestion, or you find there is torture, whatever recommendations you write on the book may not be attended to, but in your subsequent visit, you're likely to make a recommendation to either the Chief Justice or the head of the judiciary for now a scheduled visit with the prosecutors, with the National Human Rights Commission, to just go and now as a team, a planned visit, to be able to go and address a combination of issues. Because as yesterday when Aneke made her presentation, it's like, go and identify one issue and work around that one issue. If it is congestion, as a visiting justice, give feedback to the judiciary. Maybe you are not the judge who is presiding over that particular area, but somebody should be aware of congestion in prison A or prison B. Then what Judge Kalembera said, organize, and Judge, you are to tell us what that was all about, a site court inside the prison. So out of justice visit, there could be that kind of an activity in that particular prison. Now you go in, prosecutor, the lawyers, bar association, bar society, and you decongest that prison. We may not cure all the issues in a prison, because when you find congestion, you may recommend build another prison. I don't think that will be the role of the judge. But congestion from a justice view is release those short-term offenders or those who have been in custody for long, but again, apply the due process.
Thank you for the comments. That was the group's presentation. Much as I would like to stand here, I must leave.
I think it was very in-depth, and I think we're all at a different, we're starting to think about these issues in great detail, and I think it's going to be good for the final version. We'll incorporate all the changes. Can I ask the group on national human rights institutions? Doreen, is that you? Yes. Are you doing it in track changes, or you're just reporting on key issues we should change? Okay. Okay, sure.
Okay, so, and I hope if I accidentally misrepresent my group, please feel free to chime in. And I would like to piggyback on the protocols that were observed yesterday. So our group were looking at the section 9, all right, provision 9 on the national human rights institutions. And it's a very long section. There's a lot of robust conversation, but in general, in summary, we were in agreement with everything that was there. There was an initial discussion as well about whether or not it might also not be, if it's not too specific for a model law, and that, but then that's something that will be, addressed later. But we agreed that a lot of the provisions, or all the provisions here, would be necessary for the effectiveness of an NHRI in its function of conducting oversight in correctional centers. Just a couple of comments or just things to flag from the group was that the trouble is that different NHRIs and different jurisdictions, have different powers or limitations in their relevant countries. So it would be necessary, possibly, if it's possible, to kind of ensure that in order for the NHRIs to be able to implement all of these things as they appear in this current draft, they would have to be at domestic level, potentially legislative reform or development to enable, the NHRIs to have certain functions cited here. So, for instance, some NHRIs might not have the powers to investigate within their legislation. Some NHRIs might not have the powers, or rather their findings or recommendations are not legally binding, for instance. So there needs to be something to take that into account and see how we can work that into this model or to enable that. There was also concerns with regards to 9.3, which is the powers of the NHRI. So point 1C, interview any prisoner privately without the presence of staff. And that maybe we should also add or include something that also talks about written complaints, right? To ensure that those written complaints are not interfered with or intercepted by corrections, because in some countries, all letters that are coming out of the prisons from incarcerated people are typically opened by corrections officials, and also heavily redacted sometimes, so that there needs to be something that ensures that any communication that comes from an incarcerated person that is directed or addressed, that is addressed towards, it's ADHD, that is directed or addressed to an NHRI should be protected from being opened by the facility, and as such protected from being tampered with, and that there should be no reprisals for that communication being sent in the first place. And so we need to think about how that can be ensured. The other conversation was, Okay, so 9.5, follow up after investigations. So the conversation here was around the NHRIs, and I think this was also kind of similar to the discussion we had just now with the section on visiting judges, with regards to when the NHRIs concluded the investigation or the inspection, and they have their recommendations, that one, we need to make sure that there is no reprisal against the NHRI necessarily, but to also ensure that the NHRI, there is accountability across the board. We should include something that allows for an opportunity to appeal or challenge findings, and this should be backed by evidence, obviously, within a specified time frame. But after that lapses or the appeal is set aside, then the NHRI's decisions should stand and be implemented within the specified time frame. And I think that's it. I don't know if I've left anything else out, if any of my colleagues, before we take questions, I guess. Okay.
Mais uma vez, Daniel, de Angola. É realmente muito importante a figura das instituições nacionais, ou as instituições de direitos humanos. É na verdade, muito interessante, e acredito que a forma como está descrita na lei modelo é o ideal para muitas realidades africanas e principalmente a nossa. Nós, em Angola, não temos uma instituição nacional de direitos humanos propriamente dita em conformidade com os princípios de Paris. Apesar de termos o procurador, a Provedoria da República, mas a nossa Provedoria da República, ela não é independente, ou seja, não tem aquela independência absoluta que nós gostávamos, ou pelo menos em conformidade com os princípios de Paris. Nós trabalhamos, eu sou diretor do Centro dos Direitos Humanos da Universidade Católica de Angola, e temos exercido este papel de visita, principalmente o trabalho com as visitas às prisões. Eu estive em Vinduque, na altura a doutora Ivone era a ministra da Justiça, a primeira vez com quem nós tivemos juntos, e por conta da Agência das Nações Unidas para Drogas, UNDC, refletimos em relação à assistência jurídica gratuita, porque nós, o Centro dos Direitos Humanos, temos garantido assistência jurídica gratuita aos reclusos dentro das prisões. E o centro, no período da pandemia, esse era um facto que eu gostava de partilhar convosco. No período da pandemia, nós criamos um sistema para garantir a comunicação dos reclusos dentro dos centros prisionais. Criamos aquilo que nós chamamos parlatório virtual, que são salas de videoconferências, e todo ele equipado, que permitiam que os reclusos pudessem comunicar com seus familiares, uma vez que no período de confinamento, no período da Covid-19, as pessoas tinham o seu direito restringido e os reclusos principalmente não podiam receber visitas. E nós fizemos um trabalho com o executivo angolano na total neutralidade, no sentido de podermos garantir o direito de comunicação entre o recluso e os seus familiares, principalmente os reclusos estrangeiros, porque os reclusos estrangeiros, principalmente, não têm direito à comunicação. É um direito extremamente fundamental. Então, este é um exemplo que eu trouxe aqui para vocês, para perceberem o quão é importante uma instituição de direitos humanos no interior dos nossos estados angolanos. Porque as instituições de direitos humanos funcionam numa neutralidade, numa completa independência. A função deles é de poder garantir e promover a divulgação dos direitos humanos no interior dos estados. Então, penso que esta aqui sim é o ponto que nós temos que dar maior atenção. O Fórum Parlamentar tem que fazer a advocacia no sentido de o Executivo no interior dos estados terem a capacidade, principalmente os parlamentares, terem a capacidade de trabalhar com essas organizações de direitos humanos. E repito que em Angola nós não temos propriamente, mas temos centros de direitos humanos que podem fazer esse papel, né? Não sei, até quando, por exemplo, essas instituições, né, podem ser criadas. Uma outra questão que seria muito importante é a que nós vimos aqui, penso que está no número 9.3, número 1, sobre os poderes, né, dessas instituições nacionais de direitos humanos. Há um poder que eu acho extremamente importante que a gente discuta sobre isso, que é a linha A, entrar em qualquer centro correcional sem aviso prévio. Na nossa realidade angolana, isso não acontece de jeito nenhum. Não é só as instituições nacionais de direitos humanos, mesmo em relação quanto às visitas serem feitas pelos juízes, porque a configuração das nossas cadeias há, na verdade, mais uma dimensão militar do que propriamente de reabilitação. O entendimento que se tem é que, por exemplo, os estabelecimentos prisionais em muitos países, como é o caso do meu país, é uma extensão, né, de uma instituição militar. Aí as regras são castrenses. Não há muita abertura para... Quando se faz um agendamento, tem que ser com aviso prévio e mais, tem que se cumprir todos os requisitos que essa instituição normalmente obriga. Então, é ali efetivamente que está o que deve ser, porque toda atuação, toda visita, toda fiscalização, toda investigação que pode ser feita num estabelecimento prisional, os parâmetros são definidos pelo próprio estabelecimento prisional. É mesmo lá as forças que dizem onde é que você deve andar, qual é o lugar que tem que visitar, qual é o lugar que não deve ir visitar. Então, essa questão aqui de visitar sem aviso prévio é um ponto fraturante e é aqui onde nós temos que, de facto, refletir e levar ao conhecimento dos parlamentares e se fazer uma advocacia para que, de facto, com a nova mentalidade de direitos humanos que nós devemos ter nos nossos países, tendo em conta a promoção de pessoas civilizadas. Então, nós temos que fazer a advocacia em relação a esse ponto, que eu acho extremamente fundamental. Muito obrigado.
Thank you very much. Yeah, I think, I see Yvonne has a hand.
I'm not sure to what extent it was shared in the group by my colleague on the Ombudsman in Namibia specifically, but I think more generally, human rights institutions, whether or not their reports are binding, because I think that's an important question. And I know in the Namibian context, their reports are not binding. They are considered to be recommendations, but the report would normally go to the National Assembly for consideration. But there hasn't been an obligation on the Assembly to actually consider the report. So what will typically happen is that a diligent member of Parliament may pick up on the report and raise questions to the Minister of Justice, who is the voice and or spokesperson for the Ombudsman in the National Assembly. Namibia is currently in the process of reviewing its legislation so that the Ombudsman can become completely independent from the executive. There isn't a challenge around independence to the extent of the substantive work, but I think the operational aspects such as budget allocation and so forth is always a bit of challenging. So there is a plan now in Namibia, and I'm sure there are many other examples, to have the Ombudsman completely extricated from the Ministry of Justice. But what I suggest we should think about is how to strengthen the report being tabled in the National Assembly and being considered so that those because once it is considered in the Assembly, it becomes almost a slightly binding document in respect of the executive, because it would then have come from the National Assembly. I'm also not sure to what extent independent pieces of legislation that Ombudsman and or national human rights organizations have, to what extent that legislation can make provision for a slightly binding report, because otherwise Ombudsman's reports also go to UN committees. For example, I know Namibia was considered last year or earlier this year at CAT, and there were very firm recommendations made by the Committee Against Torture on two things. One is that the Ombudsman should have surprise visits to prisons, and then secondly, that their reports should become something that is a bit more binding. So tabling it in Parliament and having Parliament consider it may be one way to address that issue. Thank you.
Thank you very much. That is very helpful, and I think it's a general concern, right? That this has to be established as a minimum standard somehow in this model law. Yep.
Yeah, so just to bounce off what my colleague Yvonne said, tabling it before the National Assembly is often, if not all the time, not enough, because for instance, in Mauritius, we have to do annual reports, and they are sent to the President of the Republic, and within 1 month, he has to put it before the National Assembly. But very often, nothing is done actually about any of it, because the report comes after 1 year. There have been loads of different incidents, and some of them may have, worked themselves out or whatever it is. So nothing actually comes out of it. I know that, for instance, in India, the National Human Rights Act of India makes their recommendations binding on the government, and I think I read that in Lesotho as well. I think this is the case. So whether or not to make the actual report binding or not, but at least, as my colleague said, that it must be considered, then there is that obligation from the National Assembly to actually discuss it, not just, have a report, tabled in front of them. They actually have to discuss on the content of it. And then also to make provisions for not just annual reports. So, for instance, if there are incidents, as in Mauritius, we had a really huge incident, it's not an incident, but there was a mass torture in one of our prisons a few months ago. So we have, for the first time in our 20-odd years of existence, made a report on that, and we have actually put it before the Prime Minister, who has made it public now. So this is a first for us, but I think we should make provisions for that as well, so that it is over and above the annual reports.
Thank you for that. Yeah, I think this was also a conversation in a separate consultation process as well, or discussion process about that specific point or provision, that it should be general reports that include annual reports and incident reports and any other kind of reports that can be generated by the NHRI. Thank you. Yes, Lucas?
To follow up from the inputs, especially those reports from the NHRI, would it be a workable suggestion to place an obligation on Parliament to invite input from civil society? I mean, in the South African situation, that's quite easy. That's not an issue. So I'm talking more about other jurisdictions where access by civil society may not be that easy always. So.
Excuse me, come again, Prof.
The question for me is, can we put in the model law a duty on parliaments to invite submissions from civil society on NHRI reports submitted to Parliament? In some jurisdictions, this is not a problem, but I don't think it's everywhere the same.
So Prof, when you say this is not a problem, do you mean that there exists sufficient collegiality for civil society organizations to be invited, or is it a definitive obligation that is provided for in the law?
In the South African example, when, for example, annual reports are tabled, that portfolio committee, in that case, the portfolio committee on justice, can, and typically they do invite submissions from civil society, say, well, please come and tell us what you think about the Human Rights Commission's annual report. And we make a submission, and that's it, and we can even make a verbal submission. And so that's a well-established practice, and Parliament is empowered by the Constitution to do that, and there's good precedent for it. I'm not too sure, and I think it's a good practice. I'm not too sure it's the case in other jurisdictions within SADC.
His hand, and did you also have a hand? Okay. Do you want, is this a direct, okay, yeah, okay.
So in Namibia, it's the same, it's the same for even public participation in the lawmaking process, but it's not a hardcore law or provision in a piece of legislation. So I'm not sure, if we make everything mandatory, sometimes you are likely to have resistance. So some things should be good practice. If it's not broken, let's not try and fix it. I think the countries generally have a good relationship with their citizens more generally. But once we start saying you must do this, you must do that, you may have a little bit of resistance even from governments to endorse the spirit of the model law.
Devon, Victor, please go ahead.
Yes, I think I just need to agree with you. That's very true. Like for our case, we have never been invited to give a report after the Malawi Human Rights Commission report, because most of the time they don't issue the reports to Parliament. But we have been invited by the Parliament on so many occasions. If there's an issue to do with prisons, they invite us. So each and every time, actually we are the first people to be invited. So for us, we are enjoying that privilege. So I think, just to put it the way it is, silent, because I don't think if we start saying that you must do this, they will now start in question, who are these people? So I think that's a problem.
Thank you, Victor. Any other comments or questions? Yes, sir.
I would suggest we put it in the beginning around the principles on encouraging civil society participation. So we don't make it something specific, but then when we have in a position paper, we can give examples like Namibia and wherever where they do allow those sort of processes, and then say that's something that is encouraging and facilitates transparency or something, but not actually included in the section.
Thank you. Is that everything? Great. Thank you very much.
Thank you very much. Can I ask, there was a Portuguese-speaking group. Did you have anything specifically you needed to add in relation to judges or NHRIs that hasn't been said already?
Bom dia, meu nome é Berta Zita, sou de Moçambique. O que nós queríamos acrescentar é em relação ao capítulo 8, logo no preâmbulo. Aqui onde diz, os centros correcionais também têm a obrigação de prestação de contas ao Poder Judiciário, o que pode ajudar a garantir que os prisioneiros não sejam detidos ilegalmente. O que nós queremos acrescentar é que, para além disso, tenham tratamento condigno. Acrescentar, tenham tratamento condigno. Aqui nesta secção. Detidos ilegalmente e tenham tratamento condigno. E, em relação ao capítulo 8.3, poderíamos acrescentar que, após o relatório entregue ao presidente, ao diretor, do centro correcional, o juiz deve conceder um prazo não superior a 1 mês para verificar se as recomendações estão a ser cumpridas. Se as recomendações não forem cumpridas, deve remeter um relatório à Instituição Nacional dos Direitos Humanos ou ao Escritório de Advogados para intentarem, junto do órgão competente, uma ação de responsabilização. Não sei se tem que repetir.
I think, please repeat the last point.
Se as recomendações não forem cumpridas pelo centro correcional, deve-se emitir um relatório para a instituição da Liga dos Direitos Humanos ou um escritório de advocacia para que intente, junto de um órgão competente, uma ação de responsabilização por incumprimento.
Thank you. You can continue.
Se durante a visita for reportado caso que exija a mudança de políticas ou a reforma da lei, os juízes devem elaborar relatório que será entregue ao Ministro da Justiça.
Which section did you put it under?
Esse ponto pode fazer parte das recomendações. Não é?
Okay, it comes in afterwards. Yeah. So did you take it down? Sorry, can you repeat that section again?
Help me, sir. Help me.
Anna, just to clarify some recommendation from our colleagues. I think from the paragraph 8 on preamble, it is that in introduction part, that collection, that's line 3, collection centers also have a reporting obligation to the judicial, which can aid in ensuring that the prisoners are not detained unlawfully. So our recommendation was, we should add some words that which can aid in ensuring that prisoners are not detained unlawfully and are fairly treated. So it's not about only illegality of detention, but it's also a fairness even if they are legally detained. And in paragraph on the power of the judges, duties of the visiting judges, and on the monitoring process, the recommendation has been that once the judges make recommendation, some recommendation need quick follow-up. So at least they should not wait another routine day. In between here, they may cross-check to see that if the recommendation are implemented, especially those which need attention. Example, some serious human rights violation. You cannot wait for 3 months. So the judge should have power to cross-check with the authority to follow up if there are implementation of the said recommendation. And the last part, the reporting duties of visiting judges. So in our discussion, we said that on visit in prison, the judge might find some issues which need to be implemented by the head of prison. The other issues might be implementation by the higher authority. She gave an example of the recommendation on the change of the law, on the change of the policy, on the change of the practice. That cannot be implemented by the head of prison or by the head of collection service. So those kind of recommendation, if it's about change of the law or so, or the practice might go to the relevant authority, if it's the Minister of Justice or the Minister of Home Affairs in other countries. So that's about what kind of the report. So we are saying that where you send the report, it will depend to the type of recommendation. So it's if we think that it's within prison authority, then you have to send there. If it's in the higher authority, you have to send it to the relevant authority. I think those were the comments. So where do we put them? Especially on follow-up in a reporting mechanism, in the report follow-up mechanism. That's, I think, in paragraph 8.3, reporting duties of visiting judges. So that's where you can have such type of separate type of reports.
Are you done, Jebra?
Yes, I'm done.
Okay, can you refer back to Judge Bertha, please? Judge Bertha, did we cover everything?
Nós achamos que sim.
Thank you very much. Thank you, Judge. I think this is very critical because our civil law systems and common law systems do differ, and we need to make sure that we properly capture the duties of judges within civil law systems. Where there's a gap also, and I want to flag it to our colleagues, perhaps for you to look into it, is what is not here is an explanation really of the duties of prosecutors when they visit prisons. And prosecutors only visit them in civil law countries. And at the moment, they sort of just put under visiting justices, but they might have specific duties that we haven't really thought about or acknowledged. And my worry would be that when we then take the model law out for consultation, is that colleagues from civil law countries would say that, but you didn't properly speak about what we're doing relating to prosecutors. So if I can just ask that we perhaps have a separate follow-up meeting with our colleagues from Mozambique and Angola and Mauritius and Madagascar to speak specifically around just that issue and the DRC as well. So we might schedule that as a separate perhaps online meeting or something like that, but I do think there's a gap there and we just need to be aware of it. Are you okay on that one? Okay, cool. Are there any other additional comments on NHRIs from the Portuguese group?
The last recommendation was in paragraph 9, subparagraph 3E, on which the National Human Rights Commission was given the power that it can institute any civil action on any matter it deems fit concerning the exercise of its function under this model law. So in our recommendation was that in performance of their duties, if they find that there is the matter which is the civil action, then they might take it. But we think that there might find that there are some aspect of human right, of the criminal issues. Then in that aspect, it depends on the nature of the country. Then if it's a criminal issue, then they have to report it to the relevant authority, because in the other jurisdiction, they cannot initiate a criminal case. So either they report to the police or the office of DPP, because in the visit, you might find that there are criminal offenses committed within the prison.
So that's almost a separate subsection, right? Because this one would be civil action, and then you'd have a point around adequate referral in the case of criminal cases.
Yes.
Something like that, okay.
So it might be another paragraph, maybe E, F, G.
Thank you. Anything else? Judge? We covered. Okay, there was
It's okay. Thank you.
Thank you, Judge. There was a comment from the Ombudsman from Botswana.
Okay, this is in connection with the last comment. In fact, in terms of our legislation, it actually anticipates that in the course of investigating whether an issue of maladministration or an issue of human rights violation, you may come across conduct that speaks of criminal conduct, whether it's pure criminal conduct or corruption, and then we have a provision that then enjoins us to refer that to an investigatory body.
Thank you. So Lucas, just note that you're going to take this section from the Botswana Ombud Act. Anyone else? Okay, can I ask our French-speaking group if they have any additions to make? There were 3 of you, either on judges or on NHRIs. I know you are.
So I think the burden falls on me. So actually, it was quite interesting because our group were quite from different institutions. So my colleague from Mauritius is from the Mauritian Prison Services, and my colleague from Madagascar actually he's a doctor. So his involvement with the prison is quite different. So we kind of went a bit astray from the task that was given to us, and I think all the salient points have already been addressed, but so we sort of went also in terms of practicality and in terms of the speeches given by my colleague yesterday, in terms of medical access, psychological access inside of the prisons, and also in terms of written complaints. I think this was mentioned earlier in terms of NHRIs and how they must be protected. Well, one of the biggest problems that we have is that quite a big percentage of the prison population is illiterate. So how do you cope with that? For instance, we know that we are only getting a small percentage of complaints because it is not, it's a privilege actually to be able to make that complaint. So sorry, we went a bit astray from the task, but these are some of the issues that we thought were important to discuss and compare in different jurisdictions.
That's actually critical. Can I ask, so did you come sort of up with some innovative plan around the illiteracy issue?
So one of the proposals, which was actually done in Mauritius by welfare officers, is that, first of all, there should probably be some sort of postal box inside the prison institutions itself for the Human Rights Commission, because right now in Mauritius you have to pay postage fees, which is 25 rupees, and a whole day work is 30 rupees. So again, it's a privilege to be able to make a complaint. So first of all, to do that, to make it more accessible, and then maybe to have welfare officers be able to take complaints of those persons who cannot write. And then another alternative was that if those people who want to complain give their names to the welfare officers, then these names are then transmitted to the Human Rights Commission, and then we can go act upon that list of names. But obviously it's not a perfect system, and there can be interference from the welfare officers, because once again, you're putting more power into prison officers, even though they are welfare officers and they're supposed to be closer to the detainees than the other prison officers. But we're open to any suggestions, because it's obviously it's a big issue, and as I said, it's a privilege to be able to give a complaint.
Thank you. Do any of your colleagues in the group want to add to that?
So, thank you very much. I'd like to address the problem of mental care in prison. So many detainees actually are taking psycho drugs, and the problem is that I very often stay with the doctor, with a psychologist, that detainees complaining that they see people talking to him, and very often I seen that with other detainees, and the problem is that there's an increase in this problem between detainees, and when they receive their drugs, they sometimes share it or give it with other detainees in order to have something in return. So there is a big issue of mental health in prisons. Thank you.
Thank you. Did you want to say?
Oui, rebonjour, je suis Guy de Madagascar. Je travaille dans le domaine médical et humanitaire et à travers mes activités dans la société civile, j'ai eu à appuyer énormément les prisons et à travers des projets qu'on a mis en place. Déjà, je vais faire un petit rappel de la situation actuelle sur Madagascar. Présentement, on a le pays qui est dans une grosse crise en ce moment et le service pénitentiaire est en grève illimitée pour le moment. Donc, ça veut dire que dans ces jours-ci, il y a eu beaucoup d'arrestations de manifestants, parmi lesquels des jeunes étudiants qui manifestaient pacifiquement. Et les agents pénitentiaires ont refusé de les prendre dans les prisons. Ce qui fait qu'à un moment donné, ces étudiants ont été référés vers une autre prison, qui est une prison de travaux forcés, où ils ont été conduits là-bas par force, où on met tous les grands délinquants, où on met tous les grands criminels. Et jusqu'à présent, on n'a aucune nouvelle parce que cette prison est sous le contrôle de l'État. Donc, c'est une de nos préoccupations en ce moment. On se pose beaucoup de questions. Que va-t-il leur arriver? Que se passe-t-il? Et je vais revenir à cette crise où les agents pénitentiaires demandent à avoir à peu près un statut spécial, à avoir au niveau du ministère de la Justice un secrétariat qui soit à eux, que leurs conditions de travail soient revues et que leur espace de travail et leur milieu de travail soient bien revus. Parce qu'on est sur Madagascar, dans un pays où il y a une surpopulation estimée à peu près 1000%. Au niveau des prisons, on a toutes des prisons qui datent de l'époque coloniale. Ce qui fait qu'entre-temps, le nombre de prisonniers a presque multiplié par 10, par 20. Mais les prisons n'ont pas changé, les structures n'ont pas changé, on n'a même pas essayé d'améliorer, c'est toujours les murs de l'époque coloniale. Ça veut dire qu'on a un système d'assainissement qui est presque inexistant. Et quand j'entendais les collaborateurs dire qu'il fallait tirer la chasse, ça m'a fait peut-être sourire, peut-être de manière ironique, parce que là-bas, on est dans des salles où, peut-être des salles de 20 mètres carrés, où on met 30 à 40 personnes qui sont couchées comme des sardines dans une boîte, et chacun a son petit pot, son petit bidon dans lequel il fait ses besoins personnels. Et aujourd'hui, vraiment, l'administration pénitentiaire à Madagascar traverse cette crise-là. Et hormis cela, sur le plan sanitaire, on n'a vraiment pas de structure sanitaire dans les prisons. On a un infirmier qui est là, qui a été formé, qui essaie de faire avec ce qu'il peut faire, qui essaie de mettre, qui a souvent un prisonnier à côté de lui qu'il a formé, avec qui il travaille. Et on a énormément de problèmes de santé mentale, comme le disaient mes amis mauriciens. On a à peu près les mêmes problèmes chez nous, seulement qu'à Madagascar, c'est à un niveau encore plus élevé parce que déjà, il est déjà très difficile de parler de cela au niveau de l'administration parce que même les soins de santé de base, on n'arrive pas à vraiment on n'arrive même pas à les résoudre. Donc, quand on parle de santé mentale, même dans la société en général, même, c'est encore c'est quelque chose dont c'est une certaine classe de la société qui a accès à cela. Les gens, parfois en prison, vous diront, il y a des esprits ici, il y a des sorciers, on entend des gens courir, on entend des gens marcher, on entend des choses bizarres. En fait, quand on prend du recul avec l'analyse qu'on a, on se rend compte que c'est des problèmes de santé mentale dus à l'addiction à la drogue, au sévrage brusque et à la promiscuité, à la très mauvaise alimentation qui est là, parce que durant tout le séjour, ces gens ne mangent que du manioc dans de l'eau. Et voilà. Et on a beaucoup de cas de scorbut, on a beaucoup de cas d'intoxication alimentaire. Et je profitais par là pour dresser un peu ce tableau du système carcéral à Madagascar. Et déjà pour vous dire que dans la région SADC, c'est un des cas un peu particuliers. Peut-être compte tenu du fait que Madagascar soit une île où c'est un peu fermé, un peu insulaire, où il n'y a pas beaucoup de brassage de population. Donc je demanderai quand même à la SADC d'y jeter un coup d'œil. Je ne sais pas si les autorités pourront énormément parlementer avec vous par rapport à cela, à cause des convictions politiques, mais il faudrait quand même y jeter un coup d'œil pour cela. Merci beaucoup. Je vous remercie.
Thank you, Doctor. I think it's actually very upsetting, everything you've said. And I think it's important that you raised it here. The Secretary General can always speak about how one would raise that at the SADC Parliamentary Forum level. But that aside, I think that your group have raised a number of important issues that's not dealt with at the moment. And I think that we can't ignore that those issues happen. And it's easy for us to look at the laws that they are and to take the best laws and put it into a model law. but it doesn't then speak to the actual real situation you're facing where people are being detained not in prisons but somewhere else, where people are not getting the services they need, where correctional service staff are on strike, and where drugs create a really real problem within the institutions. And then you've mentioned other issues as well around mental health that's come up repeatedly. And I know this process isn't going to feel satisfying because it can't address those very real problems that you're facing right now. But I do think because all of us here really care about prisoners, it is incumbent on us to just think a bit further about then what, you know? And it might be in some countries you have a national preventive mechanism and there would have been a way in which you could deal with some of these issues quicker, but in other countries that's not there. And is there a way in which we can then include anything like that in here? And I'm just putting that out there. I don't know the colleague from Madagascar and the other colleagues from your group, whether they are, I don't know how the current oversight mechanisms are responding to that. And obviously you can't make provision for every eventuality that's going to happen. But I know there are exactly at this point in time similar things happening in the DRC, for example. So this is not actually uncommon. And we do need to figure out if there are prisoners having severe constraints right now, we can't create oversight mechanisms that will rock up once a year to the prison. You know, like that's not going to solve that problem, and we know these sort of problems arise all the time. So I'm just putting it out there. I know we can have a break for tea now. I'm going to take one or two comments just in case people, as the colleague from Madagascar was speaking, if it piqued something in you that you feel you need to speak about. I know there might also be people online listening to this, but I think this is important and it's a very real concern, and we want to make sure that the model law actually addresses these situations, because the reality is in any of our countries we can suddenly be in a situation that's not normal, where the rule of law isn't followed, where there are mass arrests. And in those situations you really want your oversight mechanisms to step up and be able to do something. And how do one create that situation? So is there anyone who wanted to give a comment? I know it's a very difficult question. Lucas has his hand up. Anyone else? Doreen, you've got your hand up. Okay, Lucas, go for it.
Thank you. The gentleman from Madagascar reminded me that as it stands now in the draft model law, we have not covered the powers and duties of NHRI and other visiting mechanisms during states of disaster and states of emergency. We had the unfortunate development in South Africa that during the COVID-19 lockdown, that the Judicial Inspectorate for Correctional Services was excluded from the prisons. They could not visit the prisons. Simply because the minister drafted regulations that excluded the inspecting judge and the Judicial Inspectorate from visiting prisons. So my suggestion is that we do need to cover it, and my proposal is somewhere in 7.1, powers of official visitors, that they not be restricted due to a state of disaster or state of emergency. Thanks.
That's useful. Please put that in. Doreen.
Thank you. Firstly, yes, I ditto to what Lucas has just said. But I think I just wanted to share that in our group, I think the conversation around mental health was also one of the main conversations, and how the overlap is so strong that we really need to, think deeply about the effectiveness of the oversight body in relation to incarcerated people who have mental disabilities and mental illnesses, as well as people who should. So I mean, the issues are different in different jurisdictions. For instance, in South Africa, there's the problem of having state patients, people who should be in psychiatric facilities, who wind up in correctional centers because of the overflow, right? Sorry, because of the overflow. And then I think, was it Lesotho? Yeah, where it's the other way around, where people who should be in a correctional facility in a psychiatric facility because at the time of their arrest or whatever, they could either there's misdiagnosis or no diagnosis, or people are experiencing psychotic breaks for various, whether it's circumstantial or drug induced or whatever, so that there isn't really this clear separation, and that there needs to be a lot more thought given to the issue of mental health and access to and protections of incarcerated people. Also on top of the fact that people can develop, mental illnesses due to trauma, the trauma of being deprived of your liberty, the experiences that one undergoes there, and for various other reasons. People spend long parts of their lives there. A lot of stuff can happen, whilst they're in there, including developing or triggering a pre-existing and unrecognized or diagnosed mental illness.
Before I get to Yvonne, I just want us to think about one or two things in relation to mental health, because it's coming up repeatedly, and many of our countries have persons with disabilities legislation. We're starting to get mental health legislation, but even then it's very inadequate, the laws that do exist. And for me, the issue around mental health is actually around a minimum standards issue, not necessarily an oversight issue, but the fact that I think all of us recognize that our minimum standards provisions that we look to assist us on mental health are inadequate. And that could actually be a recommendation that we make, to say that this needs to be developed further, and we can ask the SADC Parliamentary Forum, but also at UN level or whatever, that we need something better than what we have, because all of us are stumped on what to deal with mental health. That said, I think the colleague from Mauritius who mentioned welfare officers. So in the beginning of the model law, there's a complaint section, there's complaints management, what. And there are other sections around health professionals and what their duties are. And I do think in many of the discussions we've had, the issue was that you report to someone who's your complaint or your issue or your request to a person who's still part of the facility, but at least the welfare officer, honestly, is a better option than anything else I've heard, even though that person is still part of the facility. So I think we should have a separate, and perhaps later on you can brief us on that, but I think we just need to flag that there might be countries who have some better systems, whether it's social workers or welfare officers or whatever within the system, that at least, and that we should refer to also in the model law, just to recognize that there are good practices. That said, I'm handing over to Yvonne.
Mine is just a quick footnote in light of the comments that have been made before I took the floor. The one thing I think we've not clearly stipulated is a principle on aspects of non-discrimination, those prohibited grounds. So maybe that principle could come out. Then the second is, I'm just thinking about our own mental health legislation that is in Parliament now, and I'm asking myself, was this even considered? I don't think so. I don't think we really think about correctional service and inmates when we make law, regrettably, because if you even think about whether or not we have, we don't even have, I don't even remember us having separate facilities for persons with various, disabilities, and particularly mental health. So they're all just placed with everybody else, and they continue to suffer. So that may be something that we flag for follow-up. I'm now just thinking, going back, Ingrid, especially as the Ombuds may consider following up on what is the language currently in the bill that is being debated on mental health, and then also that there should be maybe a little bit more work, even if it's just whether it is virtually or us getting back to you, to the consultants, to say this is the status of the situation of people with various disabilities in our correctional facilities. That may be useful, but I think definitely we will need some stronger language around that. It may be, and thirdly, it may be useful to have a look at the Convention on the Rights of Persons with Disabilities, particularly because many of our countries, at least Namibia, has ratified that, and there may be something useful in respect of people in correctional facilities that may be useful as a guide. Thank you.
Thank you very much. And just a reminder, everyone, the email address prisons@sadicpf.org. If you have a piece of legislation or a comment or a good practice, please send that through and we will make sure it's included in either the model law or the position paper. Sasha, you had something?
Yeah, I'm just thinking about the Madagascar case, which is so distressing. And I'm also very mindful of the fact that that for this we're limiting it to correctional facilities or prisons. But I'm wondering if there's a way that we can put in some wording that refers to an obligation on the part of the department to share any information about whether they may be using other spaces to hold people or to disappear people. You know, obviously, if that's the intention, they're not going to want to share it. But to create the expectation that the oversight body should have access to all of that information.
Yeah. And those places also, but yeah.
Yes,
yeah,
and the places, but then there are a whole lot of other laws, but at least, yeah, to the places would be ideal for sure, yeah.
Okay. This is all very useful. I'm feeling we're getting somewhere. A last comment from our colleague at the back.
Yes, if you give me the permission, is another issue that I would like to raise in Mauritius prisons. Is nearly 1 year now, there was this tobacco cessation program where detainees now are not allowed to smoke. So detainees have shifted to synthetic drugs and other drugs, where now there has been an increase in violence in prison. Just yesterday, I was informed that a prison medical officer has been assaulted by a prisoner in prison. So this is a big issue now in the Mauritius prison. Thank you.
That particular person suffered from severe mental health issues. Okay, I think that's an important point to raise, and I think we should include that even in the position paper, because I've come across many similar situations where people regulate in a way that becomes counterproductive. And that those sort of ways in which you regulate, where you think, okay, brilliant plan, light bulb, we're not going to allow visitors during COVID, or we're not going to allow tobacco, and then how that backfires an impact and how decisions need to be based on evidence. And I think that's the important principle. And these are important examples for us to show why any policy decisions need to be backed up by that sort of rigorous research. This has been a very intense session. You've had to listen to really scary stories and look at laws and all of those things in a nitty-gritty way. Please take half an hour break, relax, go see the sun outside or something if it's sunny, and then we'll come back in half an hour. Thanks, everyone. Hi, everyone. I must say I really enjoyed the tea. That guacamole was very nice. We should compliment the people. This was the nicest I've had in a long time for tea, right? So I feel our hard work paid off. You can come through. Okay. 1 second. I almost thought we were on our last stage, and then I realized there's still after lunch also. Now, I know some people start switching off after lunchtime on a Friday. So I don't want to be too presumptuous and go on forever on a Friday, although this is very interesting, and I know you all feel very passionate about this project. So let me be democratic and have a check-in with the room on when would you like us to finish today? That's Judge Tawana has given an order on that side. Any other? I give preference to judges and chiefs on this question. No, and ombuds and doctors. Oh, there's way too many important people in this room. Okay, anyone else? Lunchtime might be a bit too quick, but yeah. Because I can see who we need to identify. Okay, yeah, let's do it this way. I'm going to divide us into groups for the next session. And the groups will discuss the sections that we had not yet discussed. And I'm hoping that if we do it that way, instead of all of us discussing all the sections in plenary, it will go quicker. So that we make sure everything is covered, and then we can have a brief report back, and then break for lunch. And then I have everyone's email addresses and would like to follow up with people on specific issues, and we'll set up individual meetings for that. How is that as a process? Yeah? Judge? Accept. Thank you. I've now been seconded by 2 judges, so I think I'm safe, yes, and it's my judge from South Africa, so I will follow her to the moon and back on this question. So, we have our chiefs here. I am going to ask Jebra, and find Chihamo. And then Josi from Botswana, from Malawi, and your colleague will join shortly. I'm going to ask that you have a separate group outside to specifically discuss the issue around traditional leaders. Why? Because at the moment, what is not in our model law is the district level oversight. And the district level oversight can be by chiefs, it can be by ward councillors, it can be by some sort of district thing, but there's very little, internationally even, can I say, that brings that together into something where what you observe when you see a prison translates into change. And I would like your group to discuss that a bit more. So Jebra, Tiamo, and our honourable chiefs will have a detailed discussion. Jebra, you'll make sure there's detailed notes on the issue because we want to include it in the position paper as well. That's the chiefs. Thank you. Then there's a section in the model law on parliamentary oversight. Yesterday I had quite a detailed discussion with Honourable Yvonne on the issue. She's not here, so I can call her Honourable. So she had said, we had gone through each of the sections and she was actually okay with many of them, but thought, for example, the budgetary oversight section ought not to be there. Some of the sections ought rather be encapsulated into principles, and then some other sections can say and others we deleted. However, as Advocate Polaki pointed out earlier, The issue that we hadn't dealt with is whether we can include for parliamentarians the need for them to have standing orders that requires them to look at annual reports and provide feedback to the NHRIs or whoever does the annual reports. I want people to volunteer in that group to craft that section. It's very simple, it's not a whole thing, it's about what can you tell Parliament to do, and can you tell Parliament that they must read your reports and give you feedback? Very simple. It's, yeah, can people volunteer to be in that group? I know Advocate Pilarke is in it because she made me mention it. Should we put all the Ombud people in that group? Yeah, that's fine. So Namibia, Advocate Pilarke, our Ombud from Botswana, Lesotho. Okay, you're all going to be in there, so that's perfect. You can actually take your group outside as well, and speak specifically about the interrelationship between your institutions and Parliament, and how do you get that oversight to be improved, and for what you do to actually be considered, because we recognize that to be a gap, right? Then there's a much more trickier one. And I don't know who wants to join our colleague from the NPM in Mauritius. I don't know how we reflect the NPM in this document, because so few countries have an NPM, and where they do, an NPM is a national preventive mechanism that is set up in terms of the optional protocol to the Convention Against Torture. So they focus on torture. And they are supposed to be a body reflective of various institutions who have their own mandates. And we have provisions in this version of the document that refers to torture, but we need to figure out, how it all, where the tentacles are. Now, because so few countries have national protective mechanisms, and where they do, it's often the Human Rights Commission that does it. Do we include that within the section on national human rights institutions, and just say that there ought to just reference the NPM and require referral mechanisms and coordination between them, or do we put that as a separate body? Can I have people to volunteer to address that question? It will be led by our NPM colleague. Any other people, don't leave her alone in a group. I can force all the French people to be in your group, but other people could also join, and the French interpreters will join you in your group to assist with translation. So can I have volunteers there? Which countries? I've got one volunteer, thank you very much. It's your own country volunteer, I mean, go figure. It's just because he knows he's on the aeroplane back with you and it will... But are there other people who want to... Come people, this is a very important issue. Thank you, Sasha. Okay, it is hard for people to discuss if they don't have an NPM, so that's the problem we sit with, but we want to work on an ideal world. It might be useful for someone from South Africa to also be in that group, because you do have an NPM. But Sasha will be there, so it's fine. Then what we had not discussed is independent correctional center visiting committees. And partly the reason why we hadn't discussed it is they're barely operational anywhere. But then they ought to be, so there's that. Are there people who have any experience of independent visiting committees? These can be lay visiting committees or linked to correctional or not linked to them. Have you come across them? Anyone? That's the difficulty with consulting on this section. It exists in theory. Lucas, do you want to say quickly how it works in South Africa?
Independent Correctional Centre visitors are employed by the Judicial Inspectorate for Correctional Services. They are each assigned to a prison. I think they work on a ratio of 1 visitor per 400 prisoners. So if you have a large prison, there will be multiple visitors. They typically spend 4 days a week at the prison doing inspections, interviewing prisoners, doing follow-ups. The department is divided into regions, and each region has a management area. And so all the independent visitors in a management area meet in a visitors committee. And so at that committee, the emphasis is on placing unresolved complaints. And the difference there is that the head of that particular prison, where a complaint may be coming from, is not at that meeting, but the area manager is there. So there is a hierarchy, so a complaint can jump unresolved to the area manager, and so it then follows the hierarchy down. They meet on a fairly regular basis. I'm not too sure exactly how, but let's say quarterly. So the advantage is that there is sustained monitoring. There is always somebody outside present at the prison during office hours at least. Thank you.
And Lucas, did they exist before the jigs in a different form?
No. They came with the statutory structure.
Okay, then for the record, these are one of the oldest institutions, and they do actually exist. Botswana have it in your Prisons Act of the 60s already, in visiting committees. Eswatini has it. Malawi has it. Before, the visiting committees were separate, but now they're also linked to the Judicial Inspectorate, if I'm right, Victor. I want to say Kenya has visiting committees. In some countries, so say in the UK, for example, you can apply to become a visitor. And the biggest problem with visitors is that they didn't always have the training to do the job properly, and they lacked proper feedback mechanisms to deal with what they came across. So they are part of our laws, and I want to suggest that perhaps colleagues from Malawi, Botswana, Judge Tawana perhaps, Eswatini, our Human Rights Commission person there, let's meet together on visiting committees, look through this section, and try to figure out, why do you have a section in your Prison Act that says visiting committees that isn't actually working? And how do you get that to work? Because I think, otherwise we're going to end up with the same problem with the entire model law. There are actually good existing stuff that aren't working. And I think we need to fix that. Otherwise it doesn't help we just repeat those things in here without figuring out why they don't actually work. Judge Tawana, sorry I'm giving you the lead in that group, but I know you will stick to time. So, but I think it's important because it might be that in countries where they don't report to the independent body, but where they report to correctional services, there might be a reporting gap there that makes them inefficient or something. So that section would be great if people can pay attention to it. You're welcome to do so. What I would suggest is for that group also, if you need to, you can just scan through the one-page bit of it in the position paper, because it would give you a sense of what some of the key issues are. So different countries have adopted different mechanisms for how these work, but it's not actually necessary. We've put the crux of it in the document, and you can just go through that and see, will this work in our country? Then lastly, and this is the hardest one, and I do need our oversight bodies here. And at this point, now that Lucas has left because he had an early flight, it's Judge Calumbera and Victor. I don't know who else is in a designated independent prison oversight body. NHRI, yeah, separate from NHRI. It's if you have a body that just looks at prisons and nothing else, and that's independent. Or if you want that body, to note, Eswatini, you have it in your law, you just never operationalized it. Great provision in the law, by the way. DRC has it in their law, but never operationalized it. So there's... There we go, yes. So do people perhaps... Okay, you'll go in that group. Doctor, yes.
Thank you very much, Aneke. I'm just thinking loudly, and this was inspired by what the colleague from Angola said, that which indicates that access to prison facilities in some countries is very difficult because some prisons have been militarized. That's the term he used. And I was wondering, Aneke, do we know for certain which laws exist in SADC member states which can actually frustrate access into prison facilities and therefore, by extension, jinx oversight? Because it's all very well to come up with a model law and guidelines of what we need to do as we provide oversight. But if there are laws constitutionally put in place in member states, that, I'll give you an example. Journalists, the media can play watchdog and provide oversight. But there are certain countries where a journalist cannot just rock up with a camera or a recording device and say, I want to check what is happening in here. So do we know a list of laws that exist? What is the lie of the land? What laws, what barriers exist? Because this is important for SADC Parliamentary Forum and the members of parliament as they, legislate to keep in mind.
Thanks, Doctor. That's brilliant. And I want to ask that each of our groups actually consider that. So as you note why something is not working, and what is it that perhaps is inhibiting it? Like, for example, there are laws preventing taking photographs at certain public institutions, for example, things like that. But there might also be stuff in the Constitution. I'm thinking with our National Human Rights Commission, sometimes all their powers are articulated in the Constitution, and then it might be hard to add more stuff through an act or something. So there could be many ways in which things go sideways. Honorable from Botswana.
Okay, earlier on as Doreen was presenting, we actually discussed that generally the powers of entry and inspection is normally inbuilt in the national human rights institutions legislation. Like with Botswana initially, we had the power to enter any place of detention inbuilt in the law, not correctional centers, because that recognized that even people in mental institutions, they are under detention. And then with the 2023 review, it was even opened now to being the power to enter any building or any premises without definition. So normally, it's inbuilt in the legislation.
And I think that is actually also very useful for us to, because we said we would note in the beginning that the model law might focus on prisons, but there are other places of detention that countries might want to incorporate these oversight mechanisms in. And by saying that many laws already actually provide for it, that does facilitate those sort of conversations as well. So it's definitely something to add into the discussion. Lastly, there's a question of data. Now, I know we sit here with researchers and people who love information. And how much can you ask prisons on. I have a feeling our health professionals could be very good for this section and people who love research. I'm putting it out there. Is anyone volunteering to deal with mandatory reporting? That's fine. So we already have quite a few groups, so it's okay. We don't have to do everything. Can I ask our Francophone colleagues if you can identify the groups you are in, you want to go to, and our Portuguese-speaking colleagues if you want to indicate the groups you want to go to, and then I'll kindly ask our interpreters to follow your colleagues to their groups to assist them with interpretation. Will that work? Yes? In that case, may I disperse you? You have exactly 1 hour and then you must be back here. Is that okay? Sit anywhere, make sure you have your whole group and you answer the specific questions you were given. I will come around to just refresh your mind. But your leads are Tiamo and Jebra is with the traditional leaders. Our NPM colleague from Mauritius is dealing with the NPM issue. Yvonne, Judge Calambera is dealing specifically with the section on designated oversight bodies. Judge Tawana and Judge Zuki will deal specifically with independent visiting committees. What did I leave out? Something else. Anyone? Oh, there was parliamentary oversight and standing orders, and that's Advocate Pulaki is leading on that one. So just follow the people when you see them. Yeah? Okay. Okay. Let's try and get our group started very quickly, and you can meet anywhere. Thank you, everyone.
You still able to hear me? Can you still hear me?
Okay. Right. So I was just okay. So I was just explaining that South Africa has both the NPM, which is housed in the Human Rights Commission, and then also it has an independent oversight body for prisons, which is the Judicial Inspectorate for Correctional Services. And which we call JICS for short, so that's what I'm referring to when I say JICS. So JICS is headed by an inspecting judge. So yeah, I don't know if that helps with the context. Initially, when we were establishing the NPM, South Africa had opted to basically have like a collaborative, or like what's this? Joining together the different NHRIs and independent oversight mechanisms in the country, because we have an ombud for health, an ombud for the military, and then you have the Human Rights Commission that's responsible for oversight in child and youth care facilities, as well as immigration detention. And then we have what's this, the independent policing, what's this? IPID. Investigative Directorate, right.
So that's another commission.
That's another body, oversight body, that's specifically for police. And then we then have JICS for prisons. So the initial designation that we had opted for as South Africa was instead of establishing an entirely separate or new structure for the NPM, but also acknowledging that all of these different bodies that already exist have capacity issues as well. It was better to just have a collective, of the already existing NHRIs and independent oversight bodies. And then the SPT, what's the subcommittee on torture? The subcommittee on torture was not happy with with that approach, and they basically did not officially recognize South Africa as NPM. So for the first 2-3 years we had an NPM. It was under this designation and trying to convince the SPT to recognize our NPM in this way, because also it was concerns around budget. And Treasury was like, yeah, where's this money supposed to come from, and etc., and just general resistance from the legislature. And with the pressure from the SPT, in December it was decided that, okay, fine, we'll just go with the recommendation from the SPT, which is to have the Human Rights Commission be the NPM. And then so the strategy now, because now they have to basically redesign everything, so starting from scratch, the strategy now is to find ways of bringing in the other oversight bodies who do this work, because also the Human Rights Commission is like, we don't have the money to have a separate department just for the NPM to do oversight across the country, across various kinds of detention facilities. So, and we already have bodies that are mandated to do that and that have the budgets for this. So now it's a conversation around entering into MOUs with the different structures and finding out, so basically they're still trying to figure that out.
Because I guess also there would be issues of duplicity, right? Because
Exactly.
this clearly, from what Annika said, this JICS, like they are mandated to go to prisons 4 times a week. This is more than our NPM does, because it takes a lot of manpower. And I'm guessing that's 4 times a week per prison, right? Yeah, so that's much more than the NPM in Mauritius do. So maybe I can just give you like a bit of an oversight of how we work in Mauritius. So we have our Human Rights Commission, and we are separated into 2 divisions. So the NPM is one division, and then the other division is the Human Rights Division. And so basically it's everything minus prisons and detention centers, minus police complaints, because we have an independent police complaint, minus children, because we have an ombudsperson for children. We also have an ombudsperson in general in Mauritius. And then we also have a tribunal for discrimination at work. So basically the Human Rights Division will just take everything else that I haven't mentioned. So it can, be environmental issues or other types of discrimination. So I'm just waiting for you. Okay. So the way that the NPM works is that we are mandated to visit all places of detention. So it will include prisons, it will include police cells, it includes the mental hospital. It also includes high security cells in hospitals, for instance, because some prisons have hospitals inside, but then obviously there are times where there's not that particular treatment, so they have to be moved to other hospitals. We have had talks recently about whether, when we talk about places of detention, we can also include old age homes or shelters. So it's still like we're still talking about it, but we don't have the manpower right now to do that. There's not enough of us to do that. So we are still thinking about it, but one thing that does fall underneath us is, so we also have like the correctional youth centers and things like that. So anything that's detention in general. But we also have a big problem in Mauritius about illegal stays. A lot of people from Madagascar, actually South Africa. Actually, I need to talk to who is at the Human Rights Commission in here. Is there someone from the Human Rights Commission? Oh, okay. Because we actually have 7 South African nationals right now in Mauritius that have served part of their sentences and that they want to come back. So we're trying to get, an agreement, a treaty. So I wanted to talk to someone from here, but yeah. So we have a lot of illegal stays, and they don't fall under necessarily like the correctional services, but they're not allowed to go back. So where do they go? Where do you place them? So we also have to keep an oversight
Where are they currently placed?
There is a particular shelter that take them.
Okay.
And sometimes they go to the prisons as well until it's decided that, okay, actually, no, they're just a victim and they're not actually a perpetrator, so they have no business inside the prisons. But that can take a lot of time as well. So our job is to, regularly visit those places of detention, and we make reports. So we will look at the infrastructure, we will look at the kitchen, the food, we taste the food, we look at the hospital, like what's the care. We also talk to whatever staff is there, medical staff, correctional staff, welfare officers, also detainees. Then we also receive complaints. And that's one of the issues that I was talking about earlier is that, well, we receive written complaints, but what about the 80% of the prison population that are illiterate? It's a huge number. So we know that, right now, this month, I have 120 open files. I know that this is only 20% of what it should be. So that's a huge problem. Then we also make reports based on those investigations for these particular complaints. And we are mandated under our law to have annual reports, but we are also mandated to make recommendations. So usually the way that it goes is you make recommendation to the correctional facilities, but then there are so many things that we have to understand that doesn't fall underneath them. When we're talking about overcrowding or infrastructure, well, they get their budget from somewhere, you know? So if all the prisons are overcrowded, they're getting orders from the court. So they have to take those people in. So the recommendations have to go to the different ministries, or so we fall under the Ministry of Interior. So a lot of our recommendation can escalate to him. We can also make recommendations in terms of amendments to the law if we believe that some things have to change, and we have already done this in the 3 months that we have been there. We have been making those things. So I think those are like the four main powers that we have, and then we complement those with the powers that the Human Rights Commission has. So we don't, as the NPM, we don't have the powers to summon anyone in our offices, but the other division do, because it's a quasi-judicial body. So they have the power to summon. Failing to turn up is a criminal offense. We also have the powers of entering and seizing documents. So wherever the NPM, you know, our mandate sort of restricts us, we just sort of refer the matter to the other division so that we can collaborate and get things done. The report that I was mentioning about this incident in prison in July, this is what we did. Like the NPM did the initial investigation, and then when we realized that, well, prison officers are not wanting to talk to us on the record because fear of retaliation, we then shifted the matter to the other division so that they could have actually the powers to summon, and we actually summoned officers. We even summoned the Commissioner of Prison himself. So we try to, you know, fill in the gaps where the other division has that power. I think in terms of practicality, so we have inside the NPM we have our investigators. Then we also have psychologists. And this is something which is required under our law. So to be part of it, you have some requirements. So for example, for me, I have to be a barrister of a certain year of standing. But then inside the NPM, our members, we need to have somebody from the civil society organization, which we do. And actually he is suggested by groups of civil society organizations. And then the other member is a psychologist, so that we utilize these different members and their different talents and the things that they bring, so that when we do our reports, it's not just, one-sided. We also take into account the psychology of it. We also take into account, so my colleague Michel, he worked for, 15, 20 years as the director of an NGO where they focus on the rehabilitation of detainees. So he has a different type of experience, and he also has experience and knowledge of certain officers, like relationship. Yeah, that's the word I was looking for. So we try to use all of these things together. Obviously, we're not perfect, and there are things that are lacking. For instance, if the government decides not to do anything about our report, it just goes into a drawer. And I think that's one of the biggest challenges of NHRIs around the world. Although we do have the powers to go to places of detention and to obtain information when we want, maybe that the wording of the law needs to be more precise about that, because this is a way where the other side can, try to play on it and say, well, yes, you are allowed to obtain information, but this information is too confidential, so we were not going to give it to you. And this is one of the problems I'm facing right now. Whereas for me, my interpretation of the law as a lawyer is that it says that the NPM shall obtain information pertaining to la. So for me, is as soon as I ask, I need to be given this information. But the prison services, they will say that no, this information for this and this reason, it's confidential and it's dangerous, and they might have a different interpretation of that. So I think the wording needs to be quite defined. And then also in terms of visit, obviously when we look at, it's not written in OPCAT or in the Mandela rules, but when we look at all the additional regulations that come with OPCAT and the Mandela rules, it says that you should do an announced visit. It actually says that you should, and this is what we try to do, but we have been stopped in some instances. For instance, they don't want us to, go there after working hours. Well, not working hours, but after 4 p.m. when it's lockup time because of security reasons. And some things, obviously, we do understand, but to be a proper NPM, I think that you have to be able to go there at any time of the day or night because you need to understand how things work. And actually, recently we had a case of somebody committed suicide in Melrose prison. I don't know if you know about it, Tangar. It's the same day of the Melrose incidents. One of the issues that we noticed, but this is only because we were able to have those CCTV footage, because of a certain time of the night or day that it happens, the keys to those particular cells are not kept in that particular corridor because of the difference in staff at night. So there is a whole 7 minutes that lapses from the moment that somebody realizes that something is wrong until the keys are brought. And this is something that, again, right now, for this particular issue, we were able to, well, somebody died and we were able to watch the CCTV footage, but this is why it's important for us to be able to get in at any time of the day or night. And I think this is something that the wording should also include because, this is also a thing of interpretation. If it's not clearly written, then the authorities can try to weave their ways out of it. And obviously we must understand that there are sometimes questions of security, as in if you are going there at lockup time, you need to be in presence of prison officers, so they will be short-staffed in the lockup process. But then once lockup has been done, why can't you go and visit and see how it is during lockup time? Surely, it will be actually even safer for you to be there because, well, all the detainees are going to be in their individual cells or wherever they are. So I think these are two of the biggest issues that so far we have seen in terms of the interpretation of the law and the wording. I think I've talked a lot right now, so maybe I'll...
Je peux parler?
Oui, juste attendre un petit moment qu'elle aille chercher ses écouteurs.
Oui, ok. Je vais rebondir un peu sur le mécanisme de gestion de plainte de par mon expérience de camp de réfugiés. On a souvent eu dans les camps de réfugiés humanitaires ce type de problème où on mettait en place des boîtes à suggestions ou des lignes vertes ou même des SMS gratuits que l'on pouvait envoyer. Et compte tenu du niveau d'éducation et de l'illettérisme, on était souvent confronté au fait que c'est pas tout le monde qui arrivait à répondre. Donc finalement, qu'est-ce qu'on a fait? On s'est dit dans les camps de réfugiés, il y avait un peu des leaders, il y a des leaders communautaires, là, il y a des chefs de blog, il y a tout ça. On discutait avec ces gens, on essayait de regrouper toutes les catégories de personnes qu'il y a sur le site et on essayait de réfléchir de manière commune comment est-ce qu'on pourrait adapter ces mécanismes de gestion de plainte. Donc je pense qu'il n'y aura pas un mécanisme de gestion de plainte spécifique pour toutes les prisons, mais je pense que c'est aux dirigeants, que ce soit au niveau de la prison ou au niveau de l'administration, de voir par rapport à tous ceux qui sont dans la prison, par rapport aux employés, aux détenus et à toute la sphère qui gravite autour, quels sont les mécanismes les mieux adoptés pour pouvoir mettre en place ce mécanisme. Et les gens ont surtout très peur, c'est les représailles, c'est surtout ça, comment doit se passer la gestion des données, la confidentialité dans les informations qui vont être transmises. Et après aussi, il faudrait que les gens se sentent en confiance d'aller vers ces gens. Parce que parfois, les gens ont même peur souvent d'y aller parce que je vais parler et peut-être, je vais parler peut-être à un gardien alors qu'il a des affinités avec ce chef de bloc qui essaie de me menacer depuis. Donc c'est souvent ça même qui est le nœud du problème, c'est-à-dire cibler les catégories de personnes qui sont dans la prison, cibler l'outil qui est adéquate et qui leur permet de pouvoir se justifier, pouvoir s'exprimer en face des abus dont ils sont victimes, et après maintenant pouvoir les rassurer que tout pourra se passer tout en confidentialité, tout en assurant leur sécurité. Et comme l'a dit mes deux collègues, la prison, c'est pas un endroit totalement safe. Il y a encore beaucoup de violence en prison, beaucoup de représailles. Et je me dis, si on arrive autour de cette table, j'ai quand même à mettre en place des idées, émettre des idées qui permettront d'avancer dans ce sens. Un grand pas sera fait dans nos prisons. C'est juste ce que je voudrais ajouter. Merci.
So, just to bounce
Hi, everyone. Let's start. I had promised, I'd given my word to the people at the restaurant that we will be in the restaurant at 1:30. And I'd given my word to them after that that we will leave the restaurant by 2:30 because they want to make it nice and neat. So once you're in the restaurant, don't now talk forever. Go, like I'm just saying, they've kindly requested that if we're going to, that we don't stay there forever. So in the next half an hour, I want to wrap this all up so that, and I know all the technical working group members have taken detailed notes of the discussions we've had now, and we will then work on feeding that into the draft, and then we will make sure that we send the draft to all of you here for additional input. So what I want now is just a quick reflection from each group on what you noted needs significant improvement, if there's key issues you've decided to add or detract, and if there were any other important things you wanted to add. Is that possible? We have 5 groups, each group gets 5 minutes, then we're on track. I'm going to ask the traditional leaders. No, Deborah, yes. You can speak from, no, come here. We need it for the photos.
Good afternoon. We try to answer some few questions by asking our traditional leaders on some issues. First, we try to discuss about the definition with the traditional leader. So we take some definition from Botswana and from Angola, from Malawi, but we come to conclusion that because they differ according to the structure, and we say that it might be any person recognized as such according to the laws of a particular country. That's what we agree, because they are totally different, and they perform different functions. So those are that's the kind of the definition. Then we come to the question, why chiefs should have visit? Why chiefs? Then Malawi colleagues report that because they are the one who lives with the community, with the people, so they know the people. They know what's happening with the people. So it's easy for them to monitor them. And they actually give an example that in Malawi, they also even have the book. Whenever a person is missing, they write it down. Whenever a new person comes to that village, they write it down, the chiefs. So they know the movement and the number of the people. So it's easy for them to monitor. Then from Botswana, they say that 60 to 70% of many issues, many of customary issues, start from the customary court level. So they, like 60 to 7%, most of the dispute start from that level, and they can solve it from that level. And actually, they say that traditional leaders should participate because they are part of screening of criminal justice system in the country. So that's why they say that it's very important for them to participate in prison oversight. And they say that most of the issues from Malawi start from at the lower level. And they say that sometimes traditional leaders in Malawi can even intervene if there is misbehavior or there is a dispute between prisoners themselves, prison and the prison officers. So it's very important for them to participate in oversight mechanism. And the other thing is the comment from Malawi that they have to visit because if you can visit, it's easier for them to see overcrowding, and it's very important because they can intervene at that level. They can intervene and they can confront with the government officers. That's what they are saying. But also, they say that if they visit, they will know how to integrate these people when they are coming back to the society. But once you visit, you will know the numbers. You will know who are missing. You know how many days they remain to be in custody, so that you go and start to prepare the community that so-and-so is coming after 1 month. How do you see it? So it's so important for them to visit. And in Botswana, they say that traditional leaders are the link between the government and the community. Wherever there is new law, there is the police, anything, traditional leaders are there to link between the government and the community. Then we say that we discuss what should be the right of the right and the duties of the traditional leaders when they visit. So we ask them, and they try to give us their opinion. They say that most of the important right they want is they need to have the right to access to information about the prison, prisoners, and the prison facility. So they say that they need to have that right, and they say that most of the country, they have the right to access to information. So the same applies to here, because they say that if they can facilitate, they know. Because sometimes you find that someone has been convicted to prison, but he can escape and go to another country and so on and so on. So if they can access it, they will know their people. They know how many are they. But also, they can see some people with some challenges in prison if they have that right to access. So they say that they also need to have the right to access facilities and to inspect the prison, to inspect the prison unnoticed. So they say that it's not necessary for them to give notice, because they will be visiting at their local level, not national level, within that local area. They say that they think that we need to put that according to the country level, then they need to also have the right to access to right to documentation, right to interview some people, right to inspect quality of food, and so on and so on. Those are some of the kind of the right they are saying. And also they say that there were questions about if they have this power to see a prison facility, how about the other detention centers? So that's the discussion we also have. And in reporting, they say that in Malawi, they say that they are reporting, most of them, they think that they should be reporting to the ombudsman or national human rights institution. They say that if they report to the government, yes, their reports are not taken serious or they don't act upon. So they say that most of the action they are taken by NGOs and so on. So they say that if they report to ombudsman, to national human rights institution, it will be perfect praise. But also they say that in compliance, they think that we should have the mechanism of having a committee for purpose of following up this compliance of their reports and so on. That's the opinion. Thank you.
Thank you very much. Thank you to the chiefs and everyone who participated in that group. There's a lot of content there that I think we can work with, and I think it's quite revolutionary thinking about how we can broaden participation and oversight. Which group wants to go now? Judge?
Before we get into another group, maybe just to add to what this presentation, I would like to say, in the case of Botswana and Malawi, because now I have the benefit of the Malawian law, the chiefs can go as independent visitors. And it's only the only problem is that there isn't sufficient information out there for them to know that as a local, for instance, if the chief is from Kasane, they have no access to information that you can go to the Kasane, you can be an independent prison visitor under Section 134 of the Botswana laws, Prisons Act rather. And maybe while you wait for the adaptation of this, this new protocol, they should exercise those powers under the existing laws. We discussed under our group. I don't know what the rapporteur is going to say. I don't want to preempt it, that there are still those gaps. The main gap being that people don't know of existence of such provisions of the law.
Absolutely, and I think this is also when we get to subsequent consultation stages, where we can't assume people can consult if they don't even know the actual oversight thing, which is even why in this process there was like a, there's often things one have to explain. So I think that would be very useful, and I also want to thank the chiefs, because I think you could be very helpful when we champion the submission process and the further consultations to actually explain these sort of things better. So Judge Tawana, were you volunteering to go next?
We had a rapporteur and he would do a better job.
Who's your rapporteur?
Who is the rapporteur?
Disappeared at the right time.
No, he's walking in, I think. He's just walked in.
He's just arriving. Okay, let's move on.
He always arrives at the right time.
Yes, no, and you've got them trained well, Judge. Honourable from the Eswatini Human Rights Commission, you are reporting. Would you like to come to the front? I feel I'm putting him on the spot now. Okay, I'll give you time. Is there another group volunteering? Zwandile, thank you, as always.
This was the designated independent correctional center oversight bodies. The group noted under 11.1.3 now, actually point 4. This was with regards to the report. We added a portion there. It was reading, the designated independent correctional center oversight body shall submit an annual report to the legislature and may submit additional report as required. And then what was added was the speaker shall table the report for consideration within 30 days of receipt of the report, provided that in the case of emergencies, the report shall be tabled earlier. I will forward this to you, Anek. And then we have on the same section 5, the designated body must, in the edition, be independently and adequately funded with its leadership appointed by Parliament or another independent authority. So what was added was the independently funded there. Under 11.2, 11.2.2, what we added there was the designated body. Previously it was the designated body can determine its own procedures and work methods. What we added was the designated body must determine its own procedures and work methods within 6 months from appointment. Under 11.3, on the principles, there was a lot of debate. The very introduction of that section may need to be reworked. There was a lot that was discussed. What we noted was the lack of a prevention element on the principles, but we made a note of that and we will share. Under 11.3.1a, we also added that there should be clarity on independence in the principles. The investigations must be conducted by entities independent from correctional services authorities instead of the custodial command. The other one was on 11.1d. There was this discussion around the use of the word victim or survivor, whether it should be victim or survivor, and so we added both there for discussion. And then under E, on transparency, we added confidentiality. So it now appears transparency and confidentiality. And it reads, the outcomes of investigations must be publicly, and then in parentheses we add it's either must be publicly or must be made public, subject to data protection laws and confidentiality, which was not there. The group also felt accountability was lacking there, so we added it for consideration as E. And it would read accountability, ensuring that the process is monitored must lead to accountability. And then the last one was in respect of 11.3.2. This was this read, a memorandum of understanding should exist between the designated oversight bodies, the prosecution services, the various criminal investigative structures to facilitate and monitor investigations and referral. The group felt that this takes away the independence from the different institutions and that we might consider removing this. I hope I correctly represent the group.
Thank you. Any comments? Nope. Next group. Thanks, Doreen.
Okay, so our group, we were dealing with something that's not in in the draft model, and this is looking, and that doesn't necessarily apply to most countries, which is the NPM, and trying to see if it should be worked into the model, and if so, how. And what we came up with was that we do think that, yes, as far as possible, to find ways of working in aspects of the NPM, or rather OPCAT, right, as they relate to national preventive mechanisms, into the model law, if that hasn't already happened in the current draft. But it should be something in the drafting stage. There might be things that would be applicable regardless of whether a country has signed or ratified OPCAT and whether a country has established an NPM. We also thought that it can be that these things can be included under the NHRI section. And this was based on the fact that even within the South African context, which is one of the countries that has established an NPM after a stop-start of a few years, the NPM is housed in the Human Rights Commission, similar to Mauritius as well. And this is important because it gives the NHRI legislation generally gives more powers to NHRIs than other forms of oversight bodies or independent bodies, and also most countries in the region already have, existing NHRIs. They have legislation that empowers the NHRIs, obviously, to varying degrees by country, but it will be much simpler to kind of get that adapted and included or taken on, as opposed to trying to reinvent the wheel and, scare governments into worrying about budgets and all of the other stuff. And also, it then also addresses the issue of whether or not a country has ratified or not, right? So that's what we were thinking. We also thought that, we had like a very robust conversations around the importance of acknowledging that we should also bear in mind that people who work in prisons are also affected by the negative conditions in prisons. And whilst the model law is expected to deal with prisons and primarily the concerns of prisoners, it is important to acknowledge that we should keep in mind the needs and the concerns, and also, you know, by the nature of the work, vulnerabilities to some degree of people working in prisons as well. And that this might also help with the buy-in element, but it's also just fair because it is an ecosystem, so to kind of approach it as such, and not so it's something that Moses also talked about, I think, was it yesterday? I can't remember if it was yesterday or Monday, but the conversation around communication framing, you know, so it could be something in the preamble or the principles somewhere that acknowledges that improvement of prison conditions not only benefits incarcerated people, but would also benefit the people working there and vice versa. I don't know if I've captured it properly. But yeah, and I think that was, oh yeah, so and then we also, yeah, so I think that's it. I think we've covered, oh yeah, so we also said that it's also important to specify or articulate in the NHRI, but also just across the different, you know, so the judges, the independent oversight bodies, and the NHRIs, that there needs to be care in ensuring that duplication of processes it does not occur, right? Because it undermines what the work we're trying to do, because it also, you know, means an ineffective use of limited resources. The resources, as we know, are limited across jurisdictions. So collaboration should be something that's worked into the model law amongst the relevant oversight or the different oversight bodies to avoid duplication, but to also ensure that there's a meeting of minds, and, you know, gaps are less likely to occur if people are working together around this. I don't know if that's everything.
Sorry, can I just add one more thing that we did discuss, but we were so involved that we in the conversation, the interesting conversation, that we didn't take notes of everything. But one of the interesting and important aspects that we believed in taking OPCAT into the model is that OPCAT gives, you know, definition and also clear guidelines as to what are we, in terms of oversight, what are we talking about? We're talking about conditions of detention, we're talking about treatment of detainees. And I think, I mean, I skimmed through it's 46 pages, so I apologize if it is in there, but if it isn't, when we're talking about judges' oversight, when we're talking about parliamentary oversight, I think it's important to define what oversight we mean, and also to jump on what Doreen said about duplicity. If each institution or parties, if the different type of oversight is mentioned, then it will be easier to avoid duplication.
Excellent point. I think it's like sometimes it's in your head, but you don't put it down. So I think for us to actually clarify the different forms of oversight, it would actually help. So we'll definitely do that. The next group is Swatini, Honourable from our Human Rights Commission. Thank you.
Thank you for the opportunity. I'll be very brief. For our group, we focused on 3 issues that we think should be broadened in the scope of 10.2. So firstly, we benchmarking with countries such as Malawi and Botswana, which have comprehensive legislation that actually empower the minister responsible or the inspector directorate to ensure that these committees are put in place. So we felt strongly that this should be emphasized in 10 Secondly, we discussed the aspect of the periodic nature of the visits. We note that the model law proposes 3 times a month, which we were of the strong view that that is not practical. And we therefore propose that we consider not less than 3 times a year, which is probably quarterly. And finally, on the aspect of 10.4, we were of the strong view that perhaps we should include a reciprocal a duty on the part of the committee where the head of the correctional institution in their own instance may require the committee to do an inquiry. So we probably felt that these 3 issues should also maybe form part of the model law. Thank you.
I need a quick clarity on that one. What do you mean with the inquiry by the visiting committee? So are you saying the head of the prison can ask the visiting committee to do an inquiry? And does that affect independence?
I hear your question about independence. We didn't think about that. We're only thinking about it now. But what we were using the 2 countries and looking at their own sort of guideline, and we thought that it would be nice because we're thinking that if, as a committee or any committee member has a right or responsibility to ask questions or to make inquiries or seek clarification, there's nothing wrong if the head of prison says, you know, last week I had such and such an incident, a burning incident or something like that. Can you please check it? Not to that they demand that the committee look at that. Actually, maybe we should have used request. We thought that maybe we should open it up for the prison authorities to also ask questions or ask us to further investigate certain issues. Don't know if that covers it.
Yeah, I would just like to add that inspiration was drawn from section 135, subsection 4 of the Prisons Act of Botswana, which enjoins the minister or the commissioner, gives them power to require a visiting committee to inquire into any matter he refers to it and thereafter submit a written report to him on his findings.
So that would be that's in the cases where the committees are appointed by correctional services, and then the commissioner of correctional services can instruct them to focus on particular issues. So not necessarily the head of the facility, but at the higher level. Although I can see a point with your head of facility if the committee comes and say, for example, we've received complaints about your officers, and there might be scenarios in which the head themselves might not be aware of things. But okay, so we'll flag it out, but we'll use the Botswana legislation. Thank you very much. Advocate Palaki, our Ombud.
We were assigned a responsibility to come up with appropriate wording in relation to how we can get Parliament to implement and or action the recommendations from the NHRIs. I think first I need possibly to address the one aspect that we felt was left out. When you look at clause 9.5 of the model law, it says the NHRI's decisions are binding. And we're proposing that perhaps that should be extended, and we should possibly say that they should be final, binding, and effectual or enforceable. And again, the model law is also silent on what is expected beyond the issuance of recommendations. And we have the view that we can borrow from the South African model, and part of what it says, the Act, I just forget the specific section, we can actually say that the NHRI shall request the specified authority or institution to notify the NHRI within a period of 30 days of the steps that it proposes to take to give effect to the recommendations. And the second subsection could possibly read that if on the expiration of the period referenced, a specified institution fails to notify the NHRI of the steps that it proposes to take under that subsection, the NHRI may decide to give effect to the recommendations. And thirdly, where the state institution still fails without reasonable excuse to comply with the decision made under that subsection 2, the NHRI shall compel the state institution to comply with the decision made. And I think this is aligned with the proposed model law that will see the recommendations being deemed final, binding, and enforceable. Now, when it comes to Parliament and how we think they should proceed, we think that Parliament can play a really stronger role, and we propose that we place an obligation on the National Assembly to consider the reports, and that the process should be effective, which in our opinion currently should be, or should rather find expression within the standing orders. And to this extent, we are proposing that we have a clause that states that the NHRI may at any time submit any special report seeking compliance to the recommendations to the National Assembly. And I think this is a general clause. I mean, our legislations cover this. However, the second part of it is quite important, that the clerk of the National Assembly or the speaker in some cases shall, not later than 30 days after receipt of the special report, should table or lay the report before the National Assembly, and the designated committee shall review the report and issue a public response within 90 days, which should outline the actions the specified authority should implement or reasons for the inaction.
The NHRI shall also be granted or should be granted a right of audience upon the tabling of such reports. We have different experiences here where you find at the tabling of such reports, often at times the NHRI is not even called to Parliament when the specified authority has to come in account. And for the fact that others may actually be selective in accounting, some of the reports just fizzle out and we end up not even knowing what became of such reports. So upon submission of a report by the NHRI, the National Assembly should ensure that such reports on non-compliance are tabled and addressed within the period specified, and that redress is provided, and it should actually be communicated as well to the NHRI and the responsible authority. I thank you.
That was super. Thanks so much. And you'll just email all your notes to me just so that I make sure it's all captured. Which group is remaining? I have a feeling it's Judge Callum. No, we did do that one. We did do. Is there anyone we didn't do? No? Okay. Okay. In that case, I'm handing over to our SG, if she doesn't mind, to close the meeting. From our side, we will make sure that all of this is incorporated into track changes on the document. We'll improve the document, and I can guarantee you'll have a second bite at the cherry to finesse your language. I'll also individually communicate with people on the notes you've taken. Thanks, everyone.
Thank you very much. I guess we give the consultants a round of applause for their... Yeah, I'm in a very difficult position because I'm standing between you and lunch. So just to maybe stand on the protocol that has been established at the beginning of the session, and I will not go into any recognition at the beginning. Safe to say that it's my singular pleasure, and I speak on behalf of the SADC Parliamentary Forum, that I find myself thanking you at the end of this particular important consultation, where you ably navigated very complex, intricate, challenging realities of independence, of effectiveness, of monitoring, of reporting, and confronting issues around credibility of any process, ensuring that we look closely at what we have in the preamble around performance. What do we mean about performance? Does it matter in oversight? We try to sneak in issues around unannounced inspections, which shows that we're moving the needle for oversight in one way or the other. We also looked at oversight bodies quite intently, unrestricted access, detention areas across the board, recognized what may be evolving in most of these facilities. And ultimately, all of us benefited from a deeper appreciation and understanding of the fullness of life in prison and in detention areas, and a level of what would then equate to the ethics required to diligently execute wherever you sit in any authority or body. Dear participants, under the auspices of the SADC Parliamentary Forum, for us this demonstrates or is a testament of our commitment to participatory democracy, of inclusivity, and ensuring that we hold these meetings which help us get accustomed to holding government to account, getting accustomed to reflecting on the effectiveness of Parliament. And as we develop every model law, every consultation, it confirms the long-standing principle of collaborative practice of any parliament, which actually hinges on their representative role. Mine is just to thank you for finding the time to attend this crucial consultation. It is indeed laudable that you are finding this worthy of your contribution at the individual level and also through the constituency that you represent. We are humbled that you are interested in this elaborative framework for rights of prisoners and the environment within which they are kept. We don't want to get to litigation as an option, and we didn't go there. But I believe this is an area that remains alive in these processes. I asked the question earlier to say, what if, then what? Where do we want to go? What are the remedies? Is it only around compliance where the relevant minister will be able to do ABCD or this body does ABCD? I leave that to yourselves in terms of how indeed legal reform can affect the future. And by the nature of the prospective issues that we're looking at, I leave it to you to infuse any forward-looking innovations without affecting the current operations that we find or legislation that we find ourselves in or contradicting in any way that will not add value. Your voices in framing this particular model law for regional players and those at the national level has really been important, and I'd like to thank you. With these few words, let me wish you a good retirement, have your meals, and really allow you to retire to your homes, those who live in South Africa, and the rest of us who are traveling tomorrow, kindly travel safely. It would be remiss of me not to thank the drafters for this work that they're doing, which is quite intense. I think it's not just about evidential issues. It is also about upholding the rights of prisoners. It is also about how they're going to weave this into the evolving legal dynamics governing the issue at hand. And I would like to request you that as they go and ponder further on issues of immigration, on principles of monitoring, as I indicated, that we give them a round of applause and wish them well. From the forum, we are passionate, and I can commit we are emboldened by such processes and will continue to be at your disposal. We can undoubtedly rise to the height of any parliamentary ambition through your support. Let me thank our interpreters who are in the booths for bearing with us and helping us hear each other. I think this is quite important, and thank you very much, colleagues, for assisting us to communicate. I wish you safe travel. Good afternoon.
Sorry, SG, you didn't say anything about tomorrow's logistics for those who are leaving.
You'll get an email. But what we've been doing is that 3 hours before your flight, you should be at the reception for pickup. Yeah. And those who have not handed in their ticket stubs, kindly do so. Those who have not handed the ticket, boarding pass, yeah, kindly share.
Zabwino tu. Tizachita bwino, tizachita so participate. Ndipo ndeti zayankhula. Paka na pamapeto pache anthu aone kuti kazama yankhula. And sitikucheperaso iyayi. We are leaders. I'll send her. Okay, thank you.